Judicial process. Question. Explain alternative dispute resolution system. Question. Explain Bangalore principles. Question. Examine the tools and techniques of judicial creativity and precedent. Question. Explain judge-made law and judge-declared law. Question. Explain relations between law and justice. Question. Is judicial process an instrument of social ordering? Indian constitutional law, the new challenges. Question. Distinguish between judicial activism and judicial restraint. Question. Explain the growth of public interest litigation, PIL, in India. Question. Write a note on constitutional harmony and balance between fundamental rights and directive principles of state policy. Question. Explain briefly the brain drain by foreign education market. Question. Explain the dichotomy between secularism vis-à-vis religious freedom. 11. Explain doctrine of separation of powers, legal education and research methodology. Question. Discuss about the use of observation method. Question. Explain report writing. Question. Discuss about the use of historical and comparative research. Question. Explain the utility of scaling technique in research. Question. Object of legal research. Question. Legal education and legal aid. Law and social transformation in India. Question. Discuss the concept of women empowerment. Question. Explain Gandhism and Sarvodaya movement in India. Question. Power to the people has been materialized through the establishment of Panchayat Raj government. Question. How are the prisoners' rights protected under our constitution? Briefly explain. Question. Write about democratic decentralization, local self-government. Question. Explain the influence of language as a divisive factor. What are constitutional guarantees given to the linguistic minorities? Question. Explain alternative dispute resolution system. Alternate dispute resolution mechanism. The concept and its efficacy. It is the spirit and not the form of law that keeps the justice alive. L.J. Earl Warren. The concept of conflict management through alternative dispute resolution, ADR, has introduced a new mechanism of dispute resolution that is non-adversarial. A dispute is basically less inter partes, and the justice dispensation system in India has found an alternative to adversarial litigation in the form of ADR mechanism. New methods of dispute resolution such as ADR facilitate parties to deal with the underlying issues in dispute in a more cost-effective manner and with increased efficacy. In addition, these processes have the advantage of providing parties with the opportunity to reduce hostility, regain a sense of control, gain acceptance of the outcome, resolve conflict in a peaceful manner, and achieve a greater sense of justice in each individual case. The resolution of disputes takes place usually in private and is more viable, economic, and efficient. ADR is generally classified into at least 4 types: negotiation, mediation, collaborative law, and arbitration. Sometimes a 5th type, conciliation, is included as well, but for present purposes it can be regarded as a form of mediation. Need of ADR in India. The system of dispensing justice in India has come under great stress for several reasons, mainly because of the huge pendency of cases in courts. In India, the number of cases filed in the courts has shown a tremendous increase in recent years, resulting in pendency and delays, underlining the need for alternative dispute resolution methods. It is in this context that a resolution was adopted by the Chief Ministers and the Chief Justices of States in a conference held in New Delhi on 4 December 1993 under the chairmanship of the then Prime Minister and presided over by the Chief Justice of India. It said, "The Chief Ministers and Chief Justices were of the opinion that courts were not in a position to bear the entire burden of justice system and that a number of disputes lent themselves to resolution by alternative modes such as arbitration, mediation and negotiation." They emphasized the desirability of disputants taking advantage of alternative dispute resolution which provided procedural flexibility, saved valuable time and money and avoided the stress of a conventional trial. In a developing country like India with major economic reforms underway within the framework of the rule of law, strategies for swifter resolution of disputes for lessening the burden on the courts and to provide means for expeditious resolution of disputes, there is no better option but to strive to develop alternative modes of dispute resolution, ADR, by establishing facilities for providing settlement of disputes through arbitration, conciliation, mediation and negotiation. Impact resulting acts of ADR. The technique of ADR is an effort to design a workable and fair alternative to our traditional judicial system. It is a fast-track system of dispensing justice. There are various ADR techniques viz arbitration, mediation, conciliation, mediation arbitration, mini-trial, private judging, final offer arbitration, court-annexed ADR and summary jury trial. These techniques have been developed on scientific lines in USA, UK, France, Canada, China, Japan, South Africa, Australia and Singapore. ADR has emerged as a significant movement in these countries and has not only helped reduce cost and time taken for resolution of disputes, but also in providing a congenial atmosphere and a less formal and less complicated forum for various types of disputes. The Arbitration Act, 1940 was not meeting the requirements of either the international or domestic standards of resolving disputes. Enormous delays and court intervention frustrated the very purpose of arbitration as a means for expeditious resolution of disputes. The Supreme Court in several cases repeatedly pointed out the need to change the law. The Public Accounts Committee too deprecated the Arbitration Act of 1940. In the conferences of Chief Justices, Chief Ministers and Law Ministers of all the states, it was decided that since the entire burden of justice system cannot be borne by the courts alone, an alternative dispute resolution system should be adopted. Trade and industry also demanded drastic changes in the 1940 Act. The Government of India thought it necessary to provide a new forum and procedure for resolving international and domestic disputes quickly. Thus, the Arbitration and Conciliation Act, 1996, came into being. The law relating to arbitration and conciliation is almost the same as in the advanced countries. Conciliation has been given statutory recognition as a means for settlement of the disputes in terms of this Act. In addition to this, the new Act also guarantees independence and impartiality of the arbitrators irrespective of their nationality. The new Act of 1996 brought in several changes to expedite the process of arbitration. This legislation has developed confidence among foreign parties interested to invest in India or to go for joint ventures, foreign investment, transfer of technology and foreign collaborations. The advantage of ADR is that it is more flexible and avoids seeking recourse to the courts. In conciliation mediation, parties are free to withdraw at any stage of time. It has been seen that resolution of disputes is quicker and cheaper through ADR. The parties involved in ADR do not develop strained relations, rather they maintain the continued relationship between themselves. Arbitration and Conciliation Act, 1996. Part I of this Act formalized the process of arbitration and Part 3 formalized the process of conciliation. Part 2 is about enforcement of foreign awards under New York and Geneva Conventions. Arbitration. The process of arbitration can start only if there exists a valid arbitration agreement between the parties prior to the emergence of the dispute. As per Section 7, such an agreement must be in writing. The contract, regarding which the dispute exists, must either contain an arbitration clause or must refer to a separate document signed by the parties containing the arbitration agreement. The existence of an arbitration agreement can also be inferred by written correspondence such as letters, telex, or telegrams which provide a record of the agreement. An exchange of statement of claim and defense in which the existence of an arbitration agreement is alleged by one party and not denied by other is also considered as valid written arbitration agreement. Any party to the dispute can start the process of appointing arbitrator, and if the other party does not cooperate, the party can approach the Office of Chief Justice for appointment of an arbitrator. There are only two grounds upon which a party can challenge the appointment of an arbitrator: reasonable doubt in the impartiality of the arbitrator and the lack of proper qualification of the arbitrator as required by the arbitration agreement. A sole arbitrator or panels of arbitrators so appointed constitute the arbitration tribunal. Except for some interim measures, there is very little scope for judicial intervention in the arbitration process. The arbitration tribunal has jurisdiction over its own jurisdiction. Thus, if a party wants to challenge the jurisdiction of the arbitration tribunal, it can do so only before the tribunal itself. If the tribunal rejects the request, there is little the party can do except to approach a court after the tribunal makes an award. Section 34 provides certain grounds upon which a party can appeal to the principal civil court of original jurisdiction for setting aside the award. Once the period for filing an appeal for setting aside an award is over, or if such an appeal is rejected, the award is binding on the parties and is considered as a decree of the court. Conciliation. Conciliation is a less formal form of arbitration. This process does not require an existence of any prior agreement. Any party can request the other party to appoint a conciliator. One conciliator is preferred, but 2 or 3 are also allowed. In case of multiple conciliators, all must act jointly. If a party rejects an offer to conciliate, there can be no conciliation. Parties may submit statements to the conciliator describing the general nature of the dispute and the points at issue. Each party sends a copy of the statement to the other. The conciliator may request further details, may ask to meet the parties, or communicate with the parties orally or in writing. Parties may even submit suggestions for the settlement of the dispute to the conciliator. When it appears to the conciliator that elements of settlement exist, he may draw up the terms of settlement and send it to the parties for their acceptance. If both the parties sign the settlement document, it shall be final and binding on both. Note that in USA, this process is similar to mediation. However, in India, mediation is different from conciliation and is a completely informal type of ADR mechanism. Mediation. Mediation, a form of alternative dispute resolution, ADR, or appropriate dispute resolution, aims to assist two or more disputants in reaching an agreement. The parties themselves determine the conditions of any settlements reached, rather than accepting something imposed by a third party. The disputes may involve, as parties, states, organizations, communities, individuals or other representatives with a vested interest in the outcome. Mediators use appropriate techniques and/or skills to open and/or improve dialogue between disputants, aiming to help the parties reach an agreement, with concrete effects, on the disputed matter. Normally, all parties must view the mediator as impartial. Disputants may use mediation in a variety of disputes, such as commercial, legal, diplomatic, workplace, community and family matters. A third-party representative may contract and mediate between, say, unions and corporations. When a workers' union goes on strike, a dispute takes place, and the corporation hires a third party to intervene in attempt to settle a contract or agreement between the union and the corporation. Negotiation. Negotiation is a dialogue intended to resolve disputes, to produce an agreement upon courses of action, to bargain for individual or collective advantage, or to craft outcomes to satisfy various interests. It is the primary method of alternative dispute resolution. Negotiation occurs in business, non-profit organizations, government branches, legal proceedings, among nations and in personal situations such as marriage, divorce, parenting, and everyday life. The study of the subject is called negotiation theory. Those who work in negotiation professionally are called negotiators. Professional negotiators are often specialized, such as union negotiators, leverage buyout negotiators, peace negotiators, hostage negotiators, or may work under other titles, such as diplomats, legislators or brokers. Lok Adalat. While Arbitration and Conciliation Act, 1996 is a fairly standard Western approach towards ADR, the Lok Adalat system constituted under National Legal Services Authority Act, 1987 is a uniquely Indian approach. It roughly means, People's Court. India has had a long history of resolving disputes through the mediation of village elders. The system of Lok Adalats is an improvement on that and is based on Gandhian principles. This is a non-adversarial system, whereby mock courts, called Lok Adalats, are held by the state authority, district authority, Supreme Court Legal Services Committee, High Court Legal Services Committee, or Taluk Legal Services Committee, periodically for exercising such jurisdiction as they think fit. These are usually presided by retired judge, social activists, or members of legal profession. It does not have jurisdiction on matters related to non-compoundable offences. There is no court fee and no rigid procedural requirement, i.e. no need to follow process given by Civil Procedure Code or Evidence Act, which makes the process very fast. Parties can directly interact with the judge, which is not possible in regular courts. Cases that are pending in regular courts can be transferred to a Lok Adalat if both the parties agree. A case can also be transferred to a Lok Adalat if one party applies to the court and the court sees some chance of settlement after giving an opportunity of being heard to the other party. The focus in Lok Adalats is on compromise. When no compromise is reached, the matter goes back to the court. However, if a compromise is reached, an award is made and is binding on the parties. It is enforced as a decree of a civil court. An important aspect is that the award is final and cannot be appealed, not even under Article 226 because it is a judgment by consent. All proceedings of a Lok Adalat are deemed to be judicial proceedings and every Lok Adalat is deemed to be a civil court. Lok Adalat, people's courts, established by the government, settles dispute through conciliation and compromise. The first Lok Adalat was held in Chennai in 1986. Lok Adalat accepts the cases which could be settled by conciliation and compromise and pending in the regular courts within their jurisdiction. The Lok Adalat is presided over by a sitting or retired judicial officer as the chairman, with 2 other members, usually a lawyer and a social worker. There is no court fee. If the case is already filed in the regular court, the fee paid will be refunded if the dispute is settled at the Lok Adalat. The procedural laws and the Evidence Act are not strictly followed while assessing the merits of the claim by the Lok Adalat. Main condition of the Lok Adalat is that both parties in dispute should agree for settlement. The decision of the Lok Adalat is binding on the parties to the dispute and its order is capable of execution through legal process. No appeal lies against the order of the Lok Adalat. Lok Adalat is very effective in settlement of money claims. Disputes like partition suits, damages and matrimonial cases can also be easily settled before Lok Adalat as the scope for compromise through an approach of give and take is high in these cases. Lok Adalat is a boon to the litigant public, where they can get their disputes settled fast and free of cost. Question: explain Bangalore Principles. The Bangalore Principles of Judicial Conduct. The group recognized at the outset the need for a universally acceptable statement of principles of judicial conduct. Such a statement would explain aspects of appropriate conduct to judges, encourage informed public understanding of the judicial system, and inspire public confidence in the integrity of the judiciary. An initial draft based on a survey of existing national codes in common law countries was prepared by the coordinator. At its second meeting held in Bangalore, the group agreed upon the text of the document that came to be known as the Draft Bangalore Code of Judicial Conduct. Over the next 20 months, the Bangalore draft was widely disseminated among senior judges of both common law and civil law systems, and discussed at several conferences at which chief justices and other senior justices were present. On the initiative of the American Bar Association's Keeley offices, the Bangalore draft was translated into the national languages of Albania, Bosnia and Herzegovina, Bulgaria, Croatia, Kosovo, Romania, Serbia and Slovakia, and then reviewed by judges associations and constitutional and supreme courts of these countries. A significant contribution towards its evolving form was made by the Consultative Council of European Judges. That body, which functioned within the Council of Europe and represented at that time the judicial systems of 30 European countries, commissioned an expert study of the Bangalore draft. Thereafter, at a meeting to which the coordinator of the group and the UN Special Rapporteur on the independence of judges and lawyers were invited, it conducted a full and frank discussion from the perspective of the civil law system, and then adopted a comprehensive report on specific provisions of the draft. In the light of the comments and criticisms received and in order to ensure that the final document faithfully reflected the position of civil law jurisdictions, the Bangalore draft was revised and placed before a roundtable meeting of Chief Justices drawing principally from the civil law system, which was held at the Peace Palace at The Hague. Several judges of the International Court of Justice also participated at this meeting. The final draft that emerged from this meeting, the Bangalore Principles of Judicial Conduct, was translated into Russian, Chinese, French, Spanish and Arabic and annexed to the report presented to the 59th session of the Commission on Human Rights in April 2003 by the UN Special Rapporteur on the Independence of Judges and Lawyers. The Commission, by a resolution adopted without dissent, noted the Bangalore Principles of Judicial Conduct and brought those principles to the attention of member states, the relevant United Nations organs and intergovernmental and non-governmental organizations for their consideration. In July 2006, the Economic and Social Council of the United Nations, ECOSOC, adopted a resolution recommended to it by the UN Commission on Crime Prevention and Criminal Justice, in which it recognized the Bangalore Principles of Judicial Conduct as representing a further development of, and as being complementary to, the UN Basic Principles on the Independence of the Judiciary 1985. Accordingly, ECOSOC invited member states to encourage their judiciaries to take into consideration the Bangalore Principles when reviewing or developing rules with respect to the professional and ethical conduct of members of the judiciary. ECOSOC also invited member states to submit to the UN Secretary-General their views regarding the Bangalore Principles and to suggest revisions, as appropriate. 14 member states submitted their views concerning the Bangalore Principles of Judicial Conduct. In March 2007, in his report to ECOSOC, the UN Secretary-General noted as follows: all of the responding states welcomed the Bangalore Principles as a useful basis for the development of domestic standards and rules governing the professional conduct of judges. Many states regarded the guidance contained in the principles as a valuable tool for strengthening the independence, impartiality, integrity, propriety, competence and diligence of judges, as well as to ensure equality of treatment for all before the courts. 10 of the responding states informed the UN Secretary-General that their judiciaries had already adopted standards and rules that complied with the values and guidelines enshrined in the Bangalore Principles, while 4 reported that they were in the process of reviewing existing professional standards and rules of judicial conduct in the light of the Bangalore Principles. As mandated by ECOSOC, the comments submitted by member states were placed before an open-ended intergovernmental group of experts convened by the United Nations Office on Drugs and Crime, UNODC, in Vienna in February 2007. The Secretary-General's report added that, having considered the proposed amendments, the participants were of the view that, since the text of the principles had only recently been endorsed by ECOSOC, it was premature to consider amending it. In addition, as most of the comments were aimed at clarifying and developing the values and guidelines already contained in the principles rather than raising new points, it was felt that it would be more appropriate to insert these comments in the commentary rather than in the text of the principles itself. In July 2007, ECOSOC adopted a further resolution recommended to it by the UN Commission on Crime Prevention and Criminal Justice, in which it noted with appreciation the report of the Secretary-General on strengthening basic principles of judicial conduct, in particular the progress reported by several member states on the implementation of the Bangalore Principles of Judicial Conduct, and invited member states, consistent with their domestic legal systems, to continue to encourage their judiciaries to take into consideration the Bangalore Principles of Judicial Conduct when reviewing or developing rules with respect to the professional and ethical conduct of members of the judiciary. Question: examine the tools and techniques of judicial creativity and precedent. 1. The tools and techniques of judicial creativity and precedent. Uttarakhand Jan Morcha, AIR 1999 Supreme Court 2193. The Supreme Court has imposed restriction on judicial creativity, saying that, no doubt, role of the judiciary has been expanded to newer dimensions in recent past, but that is no justification for using judicial power for imposing such unbearable burden on the state, which in turn would be compelled to extract money out of common man's coffers to meet such massive financial burden. Suffice it to say that the above direction issued by the High Court cannot stand judicial scrutiny, and it is hereby set aside. Often a question arose for discussion that whether the judges are as competent as the legislators to mete out the needs, requirements and aspirations of the people. Judges have limited scope in lawmaking. In this respect, three things need to be kept in mind. Firstly, if the judges are considered sufficiently qualified to correctly decide upon the morality of the people, then there is no reason to consider them incompetent to gauge the needs of the people in lawmaking. Secondly, how much effort do the legislators actually expend in understanding the true needs of the people and the social implications of the law? It is not unknown that nowadays bureaucrats prepare draft of the proposed legislation and without any serious discussion in the House, same are passed as usual. Thirdly, judges rarely create a law from scratch. Their legislative role is largely restricted to filling up the gaps in the law. The judge is not to innovate at pleasure. He is not a knight-errant roaming at will in pursuit of his own ideal of beauty or of goodness. Cardozo, The Nature of the Judicial Process. Further he went on to say that, he is to draw his inspiration from settled principles. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinated to promotional necessity of order in the social life. According to Cardozo, the great generalities of the Constitution, and the content of which has been and continues to be supplied by courts from time to time. He had further opined that constitutional provisions which have a content and a significance that vary from age to age. Benjamin Cardozo opined that, in Bengal Immunity Company Limited v. State of Bihar, AIR 1955 SC 661, the Supreme Court has observed that it was not bound by its earlier judgments and possessed the freedom to overrule its judgments when it thought fit to do so to keep pace with the needs of changing times. The acceptance of this principle ensured the preservation and legitimation provided to the doctrine of binding precedent, and therefore, certainty and finality in the law, while permitting necessary scope for judicial creativity and adaptability of the law to the changing demands of society. There is no law on social disorder called sexual harassment of a woman at workplace. The Apex Court in Visakhapatnam v. State of Rajasthan, AIR 1977 SC 3011, created law of the land observing that the right to be free from sexual harassment is a fundamental right under Articles 14, 15 and 21 of the Constitution. It has been 10 years since the Honble Supreme Court issued Visakhapatnam guidelines regarding sexual harassments, but still a draft bill on the subject is waiting for enactment. As per these guidelines, every organization, whether government or public, is to have an internal complaints committee to investigate complaints regarding sexual harassment at workplace. A code of conduct is prepared for all employees and that should be incorporated in the service rules standing instructions. Sexual harassment at workplace is a criminal offense and the accused would face civil as well as criminal liabilities. Articles 141 and 142 to point out that they are couched in such wide and elastic terms as to enable the Supreme Court to formulate legal doctrines to meet the ends of justice. The only limitation therein is reason, restraint and injustice. These articles are designedly made comprehensive to enable the Supreme Court to declare law and to give such direction or pass such order as is necessary to do complete justice. This is a powerful instrument of justice placed in the hands of the highest judiciary of our country. Former CJI Anand observed that the apex court has given purposive, liberal and creative interpretation of Article 21 of the Constitution by giving it more content, meaning and purpose. In expanding the ambit of right to life and personal liberty, the court has evolved tools and techniques of compensatory jurisprudence, implemented international conventions and treaties, and issued directions for environmental justice. Law must keep pace with society to retain its relevance, therefore, judicial creativity is necessary for meeting with the ends of justice. The theory of basic structure of the Constitution is a result of the creative interpretation of the Supreme Court. Union of India, AIR 2007 Supreme Court 71. The apex court has held that this development is the emergence of the constitutional principles in their own right. It is not based on literal wordings. These principles are part of constitutional law even if they are not expressly stated in the form of rules. An instance is the principle of reasonableness which connects arts 14, 19 and 21. Some of these principles may be so important and fundamental as to qualify as essential features or part of the basic structure of the Constitution, that is to say, they are not open to amendment. Right to livelihood, right to go abroad, right to privacy, right against solitary confinement, right to shelter, right to legal aid and speedy trial, right against bar fetters, right against handcuffing, right against delayed execution, right against custodial violence, right to doctor's assistance, right to water, right to food, right to clean air and healthy environment, right to pollution-free water, right to free education up to the age of 14 years, and right of every child to full development, right against illegal arrest, are all indeed judicial creativity and the result of the creative interpretation. In State of T. N. Abu Kavur by AIR 1984 Supreme Court 326, it was held that on a careful consideration of the legal and historical aspects of the directive principles and the fundamental rights, there appears to be complete unanimity of judicial opinion of the various decisions of the Supreme Court on the point that although the directive principles are not enforceable, yet the court should make a real attempt at harmonizing and reconciling the directive principles and the fundamental rights. Reading fundamental rights in the directive principles is a technique of judicial creativity. For the first time, the right to know about the candidate standing for election has been brought within the sweep of Art. 19. 1a, by the Supreme Court through its creative interpretation. The apex court in People's Union for Civil Liberties, PUGL, v. Union of India, AIR 2003 Supreme Court 2363, has held that voters' right to know about the antecedents of the candidate contesting for the election falls within the realm of freedom of speech and expression guaranteed by Art. 19. 1a, and can be justified on good and substantial grounds. In Balco Employees Union, Red, v. Union of India, AIR 2002 Supreme Court 350. The Apex Court has cautioned that there are some of the dangers in public interest litigation which the court has to be careful to avoid. It is also necessary for the court to bear in mind that there is a vital distinction between locus standi and justifiability, and it is not every default on the part of the state or a public authority that is justiciable. The court must take care to see that it does not overstep the limits of its judicial function and trespass into areas which are reserved to the executive and the legislature by the Constitution. It is a fascinating exercise for the court to deal with public interest litigation because it is a new jurisprudence which the court is evolving, a jurisprudence which demands judicial statesmanship and high creative ability. In State of Bihar v. Balmukund, AIR 2000 Supreme Court 1296, the Supreme Court has emphasized its creative role in achieving the goal of socio-economic justice. The judiciary has, therefore, a socio-economic destination and a creative function. It has to use the words of G. Austin, to become an arm of the socio-economic revolution and perform an active role calculated to bring social justice within the reach of the common man. It cannot remain content to act merely as an umpire, but it must be functionally involved in the goal of socio-economic justice. The entitlement of the accused to speedy trial has been repeatedly emphasized by the Supreme Court. Though it is not enumerated as a fundamental right in the Constitution, the Apex Court has recognized the same to be implicit in the spectrum of Article 21. In Hossanara Khatun v. Home Secretary, State of Bihar, AIR 1979 SC 1360, the court, while dealing with the cases of under-trials, who had suffered long incarceration, held that a procedure which keeps such large number of people behind bars without trial so long cannot possibly be regarded as reasonable, just or fair so as to be in conformity with the requirement of Article 21. The court laid stress upon the need for enactment of law to ensure reasonable, just and fair procedure which has creative connotation after Maneka Gandhi's case, 1978, 1 SCC 248 in the matter of criminal trials. In Municipal Corporation of Greater Bombay v. Indian Oil Corporation Limited AIR 1991 Supreme Court 686, has held that keeping in view the social, economic and political goal setting in which it is intended to operate, judge is called upon to perform a creative function. He has to inject flesh and blood in the dry skeleton provided by the legislature and by a process of creative interpretation, invest it with a meaning which will harmonize the law with the prevailing concepts and values and make it an effective instrument for delivering justice. In Delhi Transport Corporation v. Mazdoor Congress, AIR 1991 SC 101, Sabyasachi Mukherjee, former CJI, said that I am definitely of the opinion that time has come for the judicial interpretation to play far more active, creative and purposeful role in deciding what is according to law. I believe that we must do away with the childish fiction that law is not made by the judiciary. Austin, in his jurisprudence, 4th edition, has described the Blackstone's principle of finding the law as the childish fiction. Chief Justice K. Subba Rao in L. Golaknath v. State of Punjab, AIR 1967 SC 1643 at p. 1667, has referred to these observations. The Supreme Court under Art. 141 of the Constitution is enjoined to declare law. The expression, declared, is wider than the words, found or made. To declare is to announce opinion. Indeed, the latter involves the process, while the former expresses result. Interpretation, ascertainment and evolution are parts of the process, while that interpreted, ascertained or evolved is declared as law. The law declared by the Supreme Court is the law of the land. To deny this power to the Supreme Court on the basis of some outmoded theory that the court only finds law but does not make it, is to make ineffective the powerful instrument of justice placed in the hands of the highest judiciary of this country. I would, therefore, plead for a more active and creative role for the courts in declaring what the law is. Great artistry and skill is needed to fill in the gaps because Acts of Parliament were not drafted with divine prescience and perfect clarity. It is not possible for the legislators to foresee the manifold sets of facts and controversies which may arise while giving effect to a particular provision. Indeed, the legislators do not deal with the specific controversies. When conflicting interests arise or defect appears from the language of the statute, the court by consideration of the legislative intent must supplement the written word with force and life. C. The observation of Lord Denning in Seaford Estate Limited Ashaya, 1949, 2 kilobyte 481 at p. In Sher Singh v State of Punjab, 1983, 2 SCR 582. The Apex Court explained that the horizons of Article 21 are ever widening and the final word on its conspectus shall never have been said. So long as life lasts, so long shall it be the duty and endeavor of this court to give to the provisions of our Constitution a meaning which will prevent human suffering and degradation. Therefore, Article 21 is as much relevant at the stage of execution of the death sentence as it is in the interregnum between the imposition of that sentence and its execution. The essence of the matter is that all procedure, no matter the stage, must be fair, just and reasonable. Article 21 thus received a creative connotation. The Supreme Court in Jagdambika Pratap Narayan Singh v Central Board of Direct Taxes, AIR 1975 SC 1816, dealing with the question of limitation in granting a relief, has observed that any legal system, especially one evolving in a developing country, might permit judges to play a creative role and innovate to ensure justice without doing violence to the norms set by legislation. The role of the court is creative rather than passive, and it assumes a more positive attitude in determining facts and circumstances of each case. Justice Cardozo approvingly quoted President T. Roosevelt's stress on the social philosophy of the judges, which shakes and shapes the course of a nation and, therefore, the choice of judges for the higher courts which makes and declares the law of the land, must be in tune with the social philosophy of the Constitution. Not mastery of the law alone, but social vision and creative craftsmanship are important inputs in successful justicing. One as quoted in S. President of India, AIR 1982 SC 149. Creativity in Maneka Gandhi's case is clearly visible when the Supreme Court has took the view that Article 21 affords protection not only against executive action but also against legislation, and any law which deprives a person of his life or personal liberty would be invalid unless it prescribes a procedure for such deprivation which is reasonable, fair and just. The concept of reasonableness, it was held, runs through the entire fabric of the Constitution, and it is not enough for the law merely to provide some semblance of a procedure, but the procedure for depriving a person of his life or personal liberty must be reasonable, fair and just. 1. Maneka Gandhi v Union of India, AIR 1978 SC 597. Legislating, exactly in the way in which a legislature legislates, and he observes by reference to a few cases that the guidelines laid down by court, at times, cross the border of judicial lawmaking in the realist sense and trench upon legislating like a legislature. Directions are either issued to fill in the gaps in the legislation or to provide for matters that have not been provided by any legislation. Statute has to be interpreted as a whole and with reference to specific context in question. If it appears to the court any gap in the legislation, unmerited prejudice and hardship have been caused to the citizens, the court may have to depend on its own creativity so that hardship is not meted out to the people. Professor S.P. Sathe, in his work, year 2002, Judicial Activism in India, Transgressing Borders and Enforcing Limits, touches the topic, Directions, a new form of judicial legislation, evaluating legitimacy of judicial activism. The learned author has cautioned against courts not to cross the border in the name of creativity. The court has taken over the legislative function not in the traditional interstitial sense but in an overt manner and has justified it as being an essential component of its role as a constitutional court. P. 242. In Delhi Transport Corporation v. Mazdoor Congress, AIR 1991 Supreme Court 101, it is true that judicial jealousy of legislature in lawmaking has long been outdrawn, but the strict construction remains still an established rule. It is generally accepted principle that judges in interpreting statutes should give effect to the legislator's intent. By doing so, the courts do recognize their subordinate position and their obligation to help the legislature to achieve its purpose. But in that effort, creativity is essential. In State of Gujarat v. Mirzapur Moti Qureshi Kasab Jamaat, AIR 2006 Supreme Court 212, the Apex Court has held that post-Keswananda Bharti so far as the determination of the position of directive principles, vis-à-vis fundamental rights are concerned, it has been an era of positivism and creativity. Article 37 of the Constitution, which while declaring the directive principles to be unenforceable by any court, but in Keswananda Bharti v. State of Kerala, AIR 1973 SC 1461, Court goes on to say that they are nevertheless fundamental in the governance of the country. The end part of Article 37, it shall be the duty of the state to apply these principles in making laws, is not a pariah but a constitutional mandate. Supreme Court has held that, while interpreting the interplay of rights and restrictions, Part 3, Fundamental Rights, and Part 4, Directive Principles, have to be read together. On the basis of the above discussion, it is clear that judicial creativity is not only necessary but also inevitable. The only thing is to keep in mind that judicial creativity is permissible only in the area left open by the legislature and where it is necessary to fill up the gap in the statute so as to achieve real intent of it. If law is available on the subject, then judicial creativity must be restricted to interstitial creation of law, otherwise it would become judicial excess in the domain of legislature. A judge can discharge his creative role only when he has acquired sufficient knowledge, tools and techniques and interpretive skill of judicial creativity. Alternative dispute resolution, ADR, known in some countries, such as India, as external dispute resolution, includes processes and techniques that act as a means for disagreeing parties to come to an agreement short of. It is a collective term for the ways that parties can settle disputes, with the help of a third party. Despite historic resistance to ADR by many popular parties and their advocates, ADR has gained widespread acceptance among both the general public and in recent years. In fact, some courts now require some parties to resort to ADR of some type, usually, before permitting the parties' cases to be tried. Indeed, the 2008 expressly contemplates so-called compulsory mediation. This means that attendance is compulsory, not that settlement must be reached through mediation. Additionally, parties to transactions are increasingly turning to ADR to resolve post-acquisition disputes. The rising popularity of ADR can be explained by the increasing caseload of traditional courts, the perception that ADR imposes fewer costs than litigation, a preference for confidentiality, and the desire of some parties to have greater control over the selection of the individual or individuals who will decide their dispute. Some of the senior judiciary in certain jurisdictions, of which England and Wales is one, are strongly in favor of this ADR use of mediation to settle disputes. Contents. Salient features: alternative dispute resolution, ADR, is generally classified into at least 4 types. Sometimes, is included as a 5th category, but for simplicity may be regarded as a form of ADR can be used alongside existing legal systems such as courts within common law jurisdictions, such as the UK. ADR traditions vary somewhat by country and culture. There are significant common elements which justify a main topic, and each country or region's difference should be delegated to subpages. ADR is of 2 historic types. First, methods for resolving disputes outside of the official judicial mechanisms. Second, informal methods attached to or pendant to official judicial mechanisms. There are in addition freestanding and/or independent methods, such as mediation programs and ombuds offices within organizations. The methods are similar, whether or not they are pendant, and generally use similar tool or skill sets, which are basically subsets of the skills of negotiation. ADR includes informal tribunals, informal mediative processes, formal tribunals and formal mediative processes. The classic formal tribunal forms of ADR are arbitration, both binding and advisory or non-binding, and private judges, either sitting alone, on panels or over summary jury trials. The classic formal mediative process is referral for mediation before a court-appointed mediator or mediation panel. Structured transformative mediation as used by the U.S. Postal Service is a formal process. Classic informal methods include social processes, referrals to non-formal authorities, such as a respected member of a trade or social group, and intercession. The major differences between formal and informal processes are a. Pendency to a court procedure and b. The possession or lack of a formal structure for the application of the procedure. For example, free-form negotiation is merely the use of the tools without any process. Question: explain judge-made law and judge-declared law. In 1345, an English lawyer argued to the court, "I think you will do as others have done in the same case, or else we do not know what the law is." "It is the will of the justices," said Judge Hillary. Chief Justice Stonor broke in, "No, law is that which is right." This controversy between the two judges is still raging after 6.5 centuries. In modern terms, the problem can be phrased in order to know exactly what part do judges play in the development of law. Do judges make or declare law? Argument to this paper concentrates on the belief that in hard cases, judges can and do create new law. In the paper, It seems that there are clear indications that judges do indeed create new law where, for example, existing laws have become outdated or inappropriate. This thesis essentially stems from the views of the famous common law theorist, Hart, a legal positivist who sees the fusion of primary and secondary rules as being the determinant of what later becomes known as a legal system. But another thinker, Dworkin, is vehemently against the law-making power of the judges. For him, there is no law beyond the law. The law is a seamless web in which there will always be a right answer. This paper will analyze the philosophical hard-working debate on adjudication, taking Raj also with them, and then apply it to the practical life in the Indian context to conclude that judges make law out of what they discover in the legal field. This paper will proceed to answer two questions. 1. Is it possible to reach on a consensus on judges' role through a philosophical way? 2. Assuming that judges don't make law, then is it always possible to declare law? First question. How do judges make law? What opportunities do judges have to be creative? These are the questions which the philosophers have in the back of their mind while talking about the judge's role during adjudication. It is said that judges make new law or so-called creative especially in two fields. 1. In the development of the common law and 2. In the interpretation of statutes. Nevertheless, their freedom is restricted by the rules of precedent and the supremacy of parliament and by the rules of precedent and the rules of statutory interpretation. Judicial precedent, the application of precedent by judges, whether they are developing the common law, for e.g. in areas such as negligence or murder, or interpreting statutes, is the main mechanism whereby judges make law. Occasionally, judges are called upon to give a ruling or make a decision when faced with a situation for which there seems to be no precedent or any guiding rule. In these circumstances, judges can be said to be formulating original precedent. Thus, it is the judge's role to use his own discretion regarding when he thinks rules need to be applied, changed, improved, or abolished. For this reason, although Hart sees the function of law as being one of a system of rules, he maintains a firm belief that where there are gaps in the system, judges should use their own discretion when applying the law. Hart believes that because statutes and common law rules are often too vague and unclear, it is often inevitable in hard cases for a judge to create new law. He talks about the open texture of law means that are, indeed, areas of conduct where courts or officials striking a balance, in the light of circumstances, between competing interests, which vary in weight from case to case, must leave much to be developed. But according to Dworkin, principles are essential elements in deciding these types of hard cases. He seeks to argue that in all cases a structure of legal principles stands behind and informs the applicable rules. Principles control the interpretation of rules. Rules derive their meaning from principles. Judges, through the rules of precedent, merely discover and declare the existing law and never make new law. A judge makes a decision, not according to his own private judgment, but according to the known laws and customs of the land, not delegated to pronounce a new law, but to maintain and expound the old one. He is against the judge-made law mainly because of two objections. The first argues that elected representatives who are responsible to the people should govern a community, and when judges make law it will be an encroachment on legislative power. The second argues that if a judge makes new law and applies it retroactively in the case before him, then the losing party will be punished, not because he violated some duty he had, but rather a new duty created after the event. Countering Dworkin's first argument, Hart says that judge's power is subject to many constraints narrowing his choice, and judge's power are exercised only to dispose of particular instant cases. He cannot use these to introduce large-scale reforms or new codes. Even though if they make new law, it is in accordance with principles or underpinning reasons recognized as already have a footing in the existing law. This indeed is the very nucleus of the constructive interpretation, which is so prominent feature of Dworkin's theory of adjudication. Dworkin also talks about the discretion, but for him judges' choices are within the constraints of judgment, which he called as weak discretion. Dworkin does not deny the need for weak discretion, but he denies the existence of strong judicial discretion. Judges do not make law because the existing law provides all the resources for their decisions. A judge does not decide a case in a legal vacuum but on the basis of existing rules, which express, and, at the same time, are informed by, underlying legal principles. The task of the judge faced with a hard case is, therefore, to understand what decision is required by the whole doctrinal structure of existing law. Regarding Dworkin's second criticism, Hart says that this objection seems quite irrelevant in hard cases, since these are cases which the law has left incompletely regulated, and where there is no known state of clear established law to justify expectations. It's true that in every legal system, a large and important field is left open for the exercise of discretion by courts in rendering initially vague standards determinate, in resolving the uncertainties of statutes, or in developing and qualifying rules only broadly communicated by authoritative precedents. Nonetheless, these activities, important and insufficiently studied though they are, must not disguise the fact that both the framework within which they take place and their chief end product is one of general rules. These are rules the application of which individuals can see for themselves in case after case, without further recourse to official direction or discretion. According to Hart, law in the area of open texture is a guarded prediction of what the courts will do. Even if the rules are clear to all, the statement of it may often be made in the form of a prediction of the court's decision. But the important thing to be noted here is that the basis for such prediction is the knowledge that the courts regard legal rules not as predictions, but as standards to be followed in decision, determinate enough, in spite of their open texture, to limit, though not to exclude, their discretion. Judges do not generally, when legal rules fail to determine a unique result, intrude their personal preferences or blindly choose among alternatives, and when words like choice and discretion, or phrases such as creative activity and interstitial legislation are used to describe decisions, these do not mean that courts do decide arbitrarily without elaborating reasons for their decisions. And in case if there is any arbitrariness, then legislature is always there to negate it down. According to Rudge, also, courts do develop the law, they do not as political agents but by working out the implications of internal legal considerations. Courts in developing the law do not give expression to their personal views, nor do they reflect external social or political forces. Rather, they unravel the spirit of the law, unfold its hidden force and reveal its meaning. He says that judges can make the law even when precedent binds them by distinguishing it with the previous decision, but this is very restricted form of lawmaking subjected to two crucial conditions. Firstly, the modified rule must be the rule laid down in the precedent restricted by the addition of a further condition for its application, and secondly, the modified rule must be such as to justify the order made in the precedent. The judge's obligation is to adopt only that modification which will best improve the rule. In the exercise of their lawmaking power, the courts should, within the legally imposed restrictions, act by adopting the best rules they can find. They may make a new rule in a decision, which he thinks is a purely law-applying decision. Thus, on the basis of the above debate, discussion can be boiled down to the point that judges declare the law, and the question of their making law can be defended by saying that their invention is merely discovery of law within the existing precedents and principles. Limited choice cannot be termed as absolute power. It is just a weak discretion, as Dworkin will say it, constrained with certain limitations. Hart's open texture of law is also not enjoying the freedom from legal constraints. They have to also take guidance from the legal rules, considering them their standard. Same with Raj too. But is it always possible to declare law, taking into consideration about our practical life situation? This leads us to our second question. Second question. I believe that we must do away with the childish fiction that law is not made by the judiciary. Sabyasachi Mukherjee, CJ. In C. Ravichandran Iyer v. Justice A.M. Bhattacharjee, the court said that the role of the judge is not merely to interpret the law but also to lay new norms of law and to mold the law to suit the changing social and economic scenario, to make the ideals enshrined in the Constitution meaningful and a reality. The society demands active judicial roles which formerly were considered exceptional but now a routine. In S. P. Gupta v. President of India, the court observed, the interpretation of every statutory provision must keep pace with changing concepts and values, and it must, to the extent to which its language permits or rather does not prohibit, suffer adjustments through judicial interpretation so as to accord with the requirements of the fast-changing society which is undergoing rapid social and economic transformation. The court also went on to say that law does not operate in a vacuum. It is therefore intended to serve a social purpose, and it cannot be interpreted without taking into account the social, economic and political setting in which it is intended to operate. It is here that the judge is called upon to perform a creative function. He has to inject flesh and blood in the dry skeleton provided by the legislature, and by a process of dynamic interpretation, invest it with a meaning which will harmonize the law with the prevailing concepts and values and make it an effective instrument for delivery of justice. It is clear from the above statements that not only constitutional interpretation, but also statutes have to be interpreted with the changing times, and it is here that the creative role of the judge appears. Thus the judge clearly contributes to the process of legal development. The courts do not always follow the precedent blindly and do not always consider themselves bound by the given principles. The court does evolve new principles. However, the courts do always have to follow within the limits of the Constitution, and they cannot exceed the constitutional limits. When new societal conditions and factual situations demand the judges to speak, they, without professing the tradition of judicial lockjaw, must speak out. Also, in M.C. Mehta v. Union of India, Shri Ram, Oleum Gas, the court said that with the development and fast-changing society, the law cannot remain static and that the law has to develop its own new principles. The above decision reflects that the courts do make law, they frame new principles, interpret the statutes and the Constitution with the changing times. Question: explain relations between law and justice. Difference between law and justice. The concepts of law and justice are often confused and misinterpreted by many. While the two are strictly connected, they are not the same thing. Justice is a broad concept that is based on equality of rights, fairness and morality. Conversely, law is a body of regulations and standards set up by governments and international bodies and is, or should be, based on the idea of justice. Laws are written norms that regulate the actions of the citizens and of the government itself in all aspects, whereas justice is a principle that may or may not be universally recognized. What is law? Laws are rules and guidelines established and enforced by the government and its entities. They vary from country to country, and there is a body of international laws that applied to all states that decide to ratify certain treaties or conventions. National laws are principles and norms that regulate the behavior of all citizens and of all individuals under the government's jurisdiction. Laws are created by the government through a long and complex process, and once established they are implemented by governmental entities and interpreted by lawyers and judges. Laws establish what citizens, business, and governmental agencies can or cannot do. Although there is a set of written legislations, the judiciary system has the power to interpret them and to enforce them in all different situations. Laws vary from one country to another, or even from one state to another in the United States. That is why lawyers can only operate in the country where they passed the national exam. What is justice? Justice is a broad and somehow abstract concept based on equality of rights, fairness, kindness, dignity, moral and ethics. In a just world, we would not have discrimination, violence, abuses, poverty, slavery, and injustices in general. Therefore, all laws should be based on the idea of justice, and all governments should enforce national laws in a just and equal way. Unfortunately, this is not always the case, and laws are often broken, non-respected and/or enforced in biased and partial ways. Furthermore, justice supersedes national legislation and applies to all individuals without discriminations or limitations. Similarities between law and justice. The concepts of law and justice are fairly similar, as most laws are thought to be just and fair. Some of the main similarities between the two include: 1. Both concepts regulate human behavior and aim at creating a more just and equal environment. 2. Law should be based on the idea of justice and should be implemented and interpreted in a just manner without discriminations. And 3. Both are based on the ideas of morality, equality, order and fairness. Difference between law and justice. Although the two concepts are strictly linked, there are key differences that cannot be overlooked. 1. The term law refers to an existing and concrete set of written regulations established by the government in order to regulate and control the actions of the citizens. Conversely, justice is not a universally recognized concept and is subject to interpretations. Justice is often depicted a woman wearing a blindfold representing equality and fairness, and applying laws and regulations to all individuals without discrimination. Yet, there is no common understanding of justice, and there is no unique book or text to refer to, and 2. Laws can vary from country to country, and the process with which they are created can change as well. For instance, in democratic countries, laws are adopted following a long debate and an even longer process of checks and balances. Conversely, in authoritarian countries, laws are decided and established by the ruling party, or by the ruling person, without seeking the support of the majority. Conversely, the idea of justice is more or less consistent across all countries. Moral values and ethics tend to supersede borders and geographic divisions. Law versus justice. Building on the differences outlined in the previous section, we can identify few other aspects that differentiate law from justice. Difference between law and justice. Comparison table. Law. Justice. Laws apply within one country and to all individuals under the government's jurisdiction. Furthermore, international law applies to all countries that ratify certain covenants or implementation treaties. National laws are enforced by the government and its bodies, police, judiciary, etc., while international law is enforced by international organizations and tribunals. Justice is the underlying principle upon which all laws should be based. Yet, there is no implementation of justice as such, but laws and norms can be implemented and enforced in a just and fair way by judges, governments, lawyers and international bodies. Laws are created by politicians through a long process of checks and balances and can be approved or not by the creation country's population. The creation of a law follows a different process depending on the country, and can last few days or even months. Justice is not created, it is a broad concept that unites universal ethical and moral standards. Although it is not universally recognized, the idea of justice is based on values and principles that are intrinsic to the human nature. Summary of law and justice. The terms law and justice refer to two similar yet different concepts. The ideas of law and justice often go hand in hand but refer to two different ideas. Law is a system of regulations, standards, principles and norms created by a country's government in order to regulate the life and the actions of the citizens. Laws are found in written codes and are enforced by the government and its bodies, including security forces, police, judiciary, etc. Conversely, justice is a more abstract concept based on the idea of equality of rights and fairness. All laws should be based on the idea of justice and should be implemented and enforced in a just way without discrimination of sex, gender, age, color, race, religion, language or any other status. Question: is judicial process an instrument of social ordering? Judicial process an instrument of social ordering. Introduction. Judicial process means any judicial proceeding in connection with the dispensation of justice by any court of competent jurisdiction, and social ordering means activating the instrument of judicial process in setting right the wrong done or eliminating injustice from the society. But here we are mainly concerned with role of the constitutional courts evolving new juristic principles during the course of judicial process for upholding social order, keeping in view the need of fast changing society. Therefore, it would be appropriate to examine as to whether judicial process is an instrument of social ordering. Article 32, Instrument of Social Ordering. Article 32 of the Constitution empowers the Supreme Court to issue directions or orders or writs for enforcement of any right conferred under the Constitution for securing social justice. The Supreme Court has granted great relief in cases of social injustice to the affected groups of the society under this provision. Article 32 is an important instrument of judicial process to enforce social ordering. Article 32 of the Constitution of India itself is a fundamental right, which accorded free hand to the judicial process enabled the Supreme Court to take suitable action for the enforcement of social order. Deprivation of the fundamental rights often results into social disorder. The Supreme Court is a sentinel of all fundamental rights, and we are satisfied to see that the apex court has taken recourse of judicial process effectively in every area of social disorder to set it right and granted relief for each type of evil prevailing in the society. The Supreme Court has played positive role in implementing social order. Now it will be appropriate to examine the areas in which judicial process played a vital role in eliminating social disorder. Backward classes of the society. In Indra Sohni v. Union of India, AIR 1993 Supreme Court 477, the Apex Court has innovated concept of creamy layer test for securing benefit of social justice to the backward class, needy people, and excluded persons belonging to creamy layer. Bigamy. Bigamy is a social evil which often creates social disorder. The Apex Court has tightened the noose over those avoiding punishment by taking plea of conversion to Islam. In Lily Thomas v. Union of India, AIR 2000 SC 1650, it was held by the Apex Court that the second marriage of a Hindu husband after conversion to Islam, without having his first marriage dissolved under law, would be invalid. The second marriage would be void in terms of the provisions of Section 494 IPC, and the apostate husband would be guilty of the offence punishable under Section 494 IPC. This verdict of the Apex Court would certainly be helpful in eliminating social evil of bigamy. Bride burning. In Pandibane v. State of Gujarat, AIR 1992 SC 1817, the Apex Court held that it would be a travesty of justice if sympathy is shown when cruel act like bride burning is committed. Undue sympathy would be harmful to the cause of justice. The Apex Court directed that in such cases heavy punishment should be awarded. Bonded labourers. Bandhuya Mukti Morcha v. Union of India, AIR 1984 SC 802, is a good example of social ordering by way of judicial process. The Apex Court has tried to eliminate socio-economic evil of bonded labor, including child labor, and issued certain guidelines to be followed, so that recurring of such incidents be eliminated. Caste system and judicial process. In Lata Singh v. State of UP, AIR 2006 SC 2522, the Apex Court has given protection to the major boy and girl who have solemnized intercaste or interreligious marriage. Child labor. In MC Mehta v. State of T.N., AIR 1997 SC 699, the Supreme Court has issued direction the state governments to ensure fulfillment of legislative intention behind the Child Labor Prohibition and Regulation Act 61 of 1986. Tackling the seriousness of this socio-economic problem, the Supreme Court has directed the offending employer to pay compensation, a sum of Rs 20,000 for every child employed. Child prostitution. In Gaurav Jain v. UIAIR 1997 SC 3021, the Apex Court issued directions for rescue and rehabilitation of child prostitutes and children of the prostitutes. Dowry death. Dowry death is perhaps one of the worst social disorders prevailing in the society, which demands heavy hand of judicial process to root out this social evil. In Raja Lal Singh v. State of Jharkhand, the Supreme Court has laid down that there is a clear nexus between the death of Gayatri and the dowry-related harassment inflicted on her. Therefore, even if Gayatri committed suicide, S 304-B of the IPC can still be attracted. Equality, man and woman. In AIR India v. Narjesh Mirza, AIR 1981 SC 1829, the Apex Court declared that the provision of AIR India Service Regulation 46, I.C., or on first pregnancy whichever occurs earlier, is unconstitutional, and is violative of Article 14 of the Constitution. Female feticide and judicial process. Leading to unhindered female infanticide affecting overall sex ratio in various states, causing serious disorder in the society. In Center for Enquiry into Health and Allied Themes, Sahat, v. Union of India, AIR 2001 SC 2007, the Apex Court has held that despite the PNDT Act being enacted by the Parliament 5 years back, neither the state governments nor the central government has taken appropriate actions for its implementation. Hence, directions are issued by the court for the proper implementation of the PNDT Act, for eliminating this social evil. Goal of judicial process. Ultimate goal of judicial process, undoubtedly, is to ensure social order and to make the society safer for its people. Law cannot be effective and useful without taking recourse of judicial process in maintaining social order. Justice P. N. Bhagwati and Justice V. R. Krishna Iyer, both were of the opinion that law is an instrument of social change, social justice and social ordering. Justice Ranganath Mishra, former CJI, has rightly observed that law is a means to an end and justice is the end. Therefore, undoubtedly we can say that judicial process, which operate laws, is an instrument of social ordering. Harassment of women. The Apex Court in Vishakha v. State of Rajasthan, AIR 1997 SC 3011, created law of the land holding that the right to be free from sexual harassment is fundamental right guaranteed under Articles 14, 15 and 21 of the Constitution. The court has issued guidelines to be followed by employer for controlling harassment of women at her workplace. Immoral trafficking. Immoral trafficking has now become a widespread social disorder. This is a deep-rooted social evil has to be controlled. The Apex Court is of the opinion that accused persons are to be dealt with heavy hands of the judicial process in such cases. In State of Maharashtra v. Morg, Sajid Hussain Morg, S. Hussain, AIR 2008 Supreme Court 155, the court has rejected application for anticipatory bail, in a case where a minor girl was driven to flesh trade by accused persons, comprised of police officers, politicians and all were absconding for long time. Judicial process and social order. It is satisfying to see that achievements of judicial process in respect of social ordering has been significant. Judiciary has not shied away from its responsibility of enforcing social order. Looking to the need of our and demands of the changing society, the Supreme Court has innovated various tools and techniques for securing social order. One can see how the Supreme Court of India has innovated, case after case, various juristic principles and doctrines, for upgrading social order. Needless to say that, Articles 14, 15, 16, 17, 38, 39A and 42-47 of the Constitution of India deal with facets of social justice. Courts have played very wide role in interpreting the connection for achievements of social justice. Maintenance. In Morg, Ahmed Khan v. Shah Bano, AIR 1985 SC 945, the Apex Court, for the first time, granted maintenance to divorced Muslim women under Section 125 CRPC, ignoring her personal law, keeping in view essence of equality before law. In Dimpal Gupta v. Rajiv Gupta, AIR 2008 SC 239, the Apex Court has granted maintenance to illegitimate child under S 125 CRPC. This path-breaking judgment has given breath to the innocent children who were victim of no fault of their own. These verdicts are judicial instruments of social ordering. Need of judicial process. Noble preamble of our Constitution promises citizens of India to secure justice, inter alia, social justice, transforming social order. Judicial process has played a significant role in order to deliver social justice, by eliminating socio-economic imbalance and social injustice from the society. Outraging modesty of woman. Outraging the modesty of a woman is a serious social disorder has to be taken seriously by courts during the course of judicial process. In Kanvarpal S. Gill v. State, Adm. UT Chandigarh, the accused slapped on the posterior of the prosecutrix, Mrs. Rupan Deol Bajaj, an IAS officer, in the presence of other guests. The accused, who was then the DGP of the state of Punjab. The CJM convicted him under sections 354 and 509 IPC. Appeal filed by the accused was dismissed by the Apex Court. That by itself is setting a model for others, and it is a good example in connection to social ordering. Prevention of atrocity. When members of the SC and ST assert their rights and demand statutory protection, vested interest try to cow them down. In these circumstances, anticipatory bail is not maintainable to persons who commit such offences. Such a denial cannot be considered as violative of Article 14 as held in State of MP v. R.K. Balothia, AIR 1995 SC 1198. Rape. In State of MP v. Babulal, AIR 2008 Supreme Court 582, the court has laid down the principle that rape cases need to be dealt with sternly and severely. A socially sensitized judge is a better armor in cases of crime against women. Once a person is convicted for an offense of rape, he should be treated with a heavy hand and must be imposed adequate sentence. This goes to show that how the Supreme Court is keen in eliminating social disorder by the heavy hands of judicial process. Conclusion. Justice V. R. Krishna Iyer has rightly observed that law is not a brooding omnipotence in the sky but a pragmatic instrument of social order. Judicial process is a means of enforcing law. In the light of the above discussion, certainly it would be perfectly right to say that judicial process is an instrument of social ordering. The prominent work of Indian courts today may be seen as prosecuting poor people for petty crime. The main role of courts continues to be, as in colonial times to enforce law against, mostly poor, citizens, 2. Protect property rights, state and private, and 3. Uphold and protect the authority of state. On the other hand, in the immortal words of Supreme Court in S.P. Gupta case, the Constitution has made a revolutionary change in the role of Indian courts from being an arm of the Raj to being an instrument of Swaraj, an arm of social revolution. Question. Distinguish between judicial activism and judicial restraint. Judicial activism versus judicial restraint. Judicial activism and judicial restraint are true opposite approaches. Judicial activism and judicial restraint, which are very relevant in the United States, are related to the judicial system of a country, and they are a check against the fraudulent use of powers of the government or any constitutional body. Judicial activism is the interpretation of the Constitution to advocate contemporary values and conditions. On the other hand, judicial restraint is limiting the powers of the judges to strike down a law. In judicial restraint, the court should uphold all acts of the Congress and the state legislatures unless they are violating the Constitution of the country. In judicial restraint, the courts generally defer to interpretations of the Constitution by the Congress or any other constitutional body. In the matter of judicial activism, the judges are required to use their power to correct any injustice, especially when the other constitutional bodies are not acting. This means that judicial activism has a great role in formulating social policies on issues like protection of rights of an individual, civil rights, public morality, and political unfairness. Judicial restraint and judicial activism have different goals. Judicial restraint helps in preserving a balance among the three branches of government: judiciary, executive, and legislative. In this case, the judges and the court encourage reviewing an existing law rather than modifying the existing law. When talking about the goals or powers of judicial activism, it gives the power to overrule certain acts or judgments. For example, the Supreme Court or an appellate court can reverse some previous decisions if they were faulty. This judicial system also acts as checks and balances and prevents the three branches of government, judiciary, executive, and legislative, from becoming powerful. 1. Judicial activism is the interpretation of the Constitution to advocate contemporary values and conditions. Judicial restraint is limiting the powers of the judges to strike down a law. 2. In judicial restraint, the court should uphold all acts of the Congress and the state legislatures unless they are violating the Constitution of the country. 3. In the matter of judicial activism, the judges are required to use their power to correct any injustice, especially when the other constitutional bodies are not acting. 4. Judicial activism has a great role in formulating social policies on issues like protection of rights of an individual, civil rights, public morality, and political unfairness. 5. When talking about the goals or powers of judicial activism, it gives the power to overrule certain acts or judgments. For example, the Supreme Court or an appellate court can reverse some previous decisions if they were faulty. Question: explain the growth of public interest litigation, PIL, in India. PIL means litigation filed for the protection of public interest, like pollution, terrorism, road safety, constructional hazards, etc. Any matter where the interest of the public at large is affected is often redressed by filing a public interest litigation. The expression, public interest litigation, has been borrowed from American jurisprudence, where it had been designed to supply representation to previously unrepresented, like the poor, the racial minorities, unorganized consumers, citizens who were hooked into the environmental issues, etc. Public interest litigation is the power given to the general public by courts. The person filing the petition must convince the court that the petition is being filed for public interest and not for personal reasons. The court itself may take suo motu cognizance of the cases, may commence on the petition of any public-spirited person. Some of the matters which are considered under PIL are bonded labor matters, neglected children, non-payment of minimum wages to workers and exploitation of workers, atrocities on women, environmental pollution and disturbance of ecological balance, food adulteration, maintenance of heritage and culture, origin and evolution of PIL in India. The concept of public interest litigation was introduced for the first time in India by Justice Krishna Iyer in 1976 in the case of Mumbai Kamagar Sabha v. Abdul Tai. The first ever reported case of public interest litigation was Hussainara Khatun v. the State of Bihar, 1979, that focused on the inhumane conditions of prisons and under trials, which led to the acquittal of about 40,000 under trials prisoners. The right to speedy justice emerged as a fundamental right that was not given to those prisoners. A similar set pattern was adopted in later cases. A new period of public interest litigation movement was started by Justice P.N. Bhagwati in the case of S.P. Gupta v. Union of India. Some of the landmark judgments on PIL were Indian Banks Association, Bombay and Oz. V. M. S. Devkala Consultancy Service and Oz. M. C. Mehta v. Union of India. Vishaka v. the State of Rajasthan. Facts responsible for the growth of PIL in India. The character of the Indian Constitution. India features a written constitution which through Part 3, Fundamental Rights, and Part 4, Directive Principles of State Policy, provides a framework for regulating relations between the state and its citizens and between citizens inter se. The liberal interpretation of locus standi also means that any person can apply to the court on the behalf of the people who are financially or physically unable to return before they are helped. Judges themselves have in some cases initiated suo motu actions supporting newspaper articles or letters received. Although social and economic rights given within the Indian Constitution under Part 4 aren't legally enforceable, courts have creatively read these into fundamental rights, thereby making them judicially enforceable. For instance, the right to life in Article 21 has been expanded to include the right to free legal aid, right to live with dignity, right to education, etc. Judicial innovations to assist the poor and marginalized. In the Bandhuya Mukti Morcha case, the Supreme Court put the burden of proof on the respondent, stating it might treat every case of forced labor as a case of bondage unless proven otherwise by the employer. Similarly, in the case of Asiad workers, Justice P.N. Bhagwati held that anyone getting a wage can approach the Supreme Court directly without going to the Labour Commissioner and lower courts. In PIL cases where the petitioner isn't in a position to supply all the required evidence, either because it's voluminous or because the parties are weak socially or economically, courts have appointed commissions to gather information on facts and present it before the bench. Drawbacks related to public interest litigation. APIL may give rise to the matter of competing rights. When the court orders the closure of a polluting industry, the rights and interests of the workmen are also being violated, as their only source of livelihood is being snatched away from them, and this may not be taken into account by the court. It's for the reason that people can misuse and file frivolous PILs motivated by personal and selfish reasons or malice. The courts have reiterated time and again that PIL isn't personal interest litigation for corporate, personal, and political gains. This results in the overburdening of the courts. In the process of solving socio-economic issues or a drug related to the protection of the environment, the judiciary may in certain cases exercise judicial overreach through the PILs. There is an inordinate delay within the disposal of PIL cases, especially matters involving the poor and disadvantaged. This defeats the entire purpose of speedy justice and dilutes the importance of judgment. public interest litigation has departed from the normal system of litigation and caused a system that involves initiating an action to enforce the interest of the general public at large. Over the years, it's become a potent tool for the poor, illiterate and underprivileged to possess access to the courts and seek judicial redress by filing an application under Article 226 to the Supreme Court and Article 32 to the Supreme Court. Therefore, PIL has democratized access to justice by relaxing the rule of locus standi. Thus, any public-spirited person or social activist or group can now approach the court on behalf of a particular group or class of persons, especially the oppressed and marginalized. The main reason why PIL has flourished in India is that the Constitution of India, through its Part 3, Fundamental Rights, and Part 4, Directive Principles of State Policy, provides a framework to manage the relationship between the state and the citizens and also between citizens. The accountability of the government towards the rights and interests of the poor and disadvantaged has increased in PIL within the country. The relaxation of the normal rule of locus standi enables a person to approach the court and represent those that are socio-economically disadvantaged and unable to get redressal. Therefore, PIL has been a crucial tool in bringing about social change, upholding the rule of law enshrined under Article 14, and thereby creating a fragile balance between law and justice. Question: write a note on constitutional harmony and balance between fundamental rights and directive principles of state policy. The fundamental rights are enshrined in Part 3 of the Constitution starting from Article 12 to Article 35, and it is believed that the framers of the Constitution in this regard have rightly derived their inspiration from the Constitution of the United States, i.e. Bill of Rights. The rights thereby enshrined in Part 3 of the Constitution encompasses in itself an elongated and comprehensive list of justiciable fundamental rights that can be enforced by the ordinary courts of the country. These fundamental rights contained in Part 3 of our Constitution are much more extensive and elaborative than any other country of the world, even more elaborative from where it has been borrowed, USA. On the other hand of this article, we will explore that the directive principles of state policy, or the, herein referred to as DPSP, are encompassed in Part 4 of the Constitution of India from Article 35 to 51. It is evident at this very stage that the makers of the Constitution of India in respect to Part 4 have derived and borrowed the idea and the concept of having the directive principles from Section 45 of the Irish Constitution of 1937, which in turn have copied it from the Spanish Constitution. These directive principles of the state policy, or novel features, as termed by Dr. B.R. Ambedkar, symbolize and directs the state, as defined in Article 12 of the Constitution, with ideals and recommendations that should be kept in mind while framing policies and enacting laws, but unlike the former stands unjustifiable in nature. Both the directive principles along the fundamental rights comprise the philosophy of the Constitution. Now, we will discuss in this part of the article the Part 3 and Part 4 of the Constitution much more elaboratively. Fundamental Rights, Part 3. As discussed earlier in this article, these justiciable rights are enshrined in Part 3 of the Constitution of India, Article 12 to Article 35, and are called and named fundamental because of two significant reasons. Firstly, these rights are guaranteed and protected by the Constitution of the country, which is the fundamental law of the land. Secondly, they become fundamental in the sense that they are most essential for the all-round material, intellectual, moral, and spiritual development of an individual. Initially and originally there were about 7 fundamental rights, but after the abolition of Zamindari Act 1950, their number reduced to about 6, which are as follows. 1. Right to equality, Article 14 to 18, which entails in itself that everyone stands equal before the law and equal treatment should be given to everyone, thereby implying a complete prohibition of discrimination founded on the grounds of race, caste, creed, or gender. 2. Right to freedom, Article 19 to 22, each individual has the right to freedom to form an association, to peacefully assemble, to practice any profession, and carry on any trade, occupation, or business. Contains one of the most significant right, i.e. right to life and liberty, Article 21. Protection and rights to an accused in respect to arrest and detention for conviction of any offense under the penal code of the country. 3. Right against exploitation, Article 23 and 24. This article entails in themselves important and rights such as the prohibition of child labor or forced labor and human trafficking. 4. Right to freedom of religion, Article 25. Article 28. This specific right in the Constitution is of utmost importance in a country like India where there is a huge diversity of religion. This right provides the citizens with the freedom to follow and practice any religion and most importantly grants freedom of conscience to an individual. The rights under this head also specifically provide a clause concerning paying taxes for religious purposes. 5. Cultural and educational rights, Article 29 and Article 30. These rights entailed in Part 3 provides protection to different languages and varieties of culture present in India and additionally protects the rights and culture of minorities, right to minorities to establish and administer educational institution, etc. 6. Right to seek constitutional remedies, Article 32. As described by Dr. Ambedkar, the heart and soul of the Indian Constitution, these remedies are available to any individual whose fundamental right just violated, and these rights enshrined in the Constitution empowers the Supreme Court of India to issue 5 types of writs. However, the right to property was deleted from the aforementioned list of fundamental rights by the 44th Amendment Act, 1978, and thereby this amendment made the right to property as a non-fundamental constitutional right under Article 300-A in Part 12 of the Constitution. Directive Principles of State Policy, Part 4. The Directive Principle of State Policy or DPSP as enumerated in Part 4 of the Constitution as discussed formerly in this article are the constitutional directives or recommendations to the state as far as the cases of legislative, administrative and executive matters to keep in mind the ideals therein mentioned while formulating and enacting laws. The significance of these directives becomes evident from the fact that these directive principles at numerous instances help the court of law, though having non-justiciable in nature, to determine the constitutional validity of a law. These directives are often classified into 3 broad categories. Socialistic principles, for e.g. Article 38, to promote the welfare of the people by securing a social order permeated by justice, social, economic and political, and thereby to minimize any types of inequalities, be it income, status and opportunities. Gandhian principles. These principles characterize the program for reconstruction as enunciated by the father of the nation Mahatma Gandhi during the national movement and struggle. For e.g. Article 40 to organize village panchayats and endow them with necessary powers and authority to enable them function as units of self-government. Liberal intellectual principles. These DPSPs entail in themselves some characteristics of the ideology of liberalism. For e.g. Article 50, which further imposes an obligation upon the state to separate judiciary from the executive in the public services of the state. The classification of the directive principles as above stated in this article is not expressly present or made by the Constitution, but however on the basis of its content the same has been classified into the three broad categories. Significance of the directive principles. These directive principles, despite having been criticized by eminent economists like K.T. Shah as a check on bank, payable only when resources of the bank permit so, for having no legal sanction and being illogically arranged, and even by former Finance Minister T.T. Krishnamachari, 1956 to 1958, as a veritable dustbin of sentiments, these directive principles in the contemporary times cannot be construed as irrelevant accompaniment. As stated by Justice Chugla, the former Chief Justice of India, these principles, if implemented well and fully carried out, can make our country indeed heaven on earth. The directive principles are auxiliary and can even be considered as subsidiary to the fundamental rights, as they are aimed and intended to fill in the vacuum present in Part 3 by providing economic and social rights. They simplify and provide a kind of stability and permanency in domestic and foreign strategies of the government or despite the changes that occur from the disposition. DPSPs provide the citizens of the country a quantitative scale to measure the performance of the government and provide them with effective feedback on where it lacks. Conflict between directive principles and fundamental rights. It becomes pertinent to note at this point, even though both the directive principles of state policy and the fundamental rights appear as constitutionally distinct, but when we trace back their historical origin, we find that both had originated from a common origin. There was no distinction between positive and negative obligations of the state, but it was the Constituent Assembly that separated them. We find both the above-mentioned fundamental right and directive principle as intimate and interlacing part of the Indian Constitution. The conflict between the DPSPs and fundamental rights seems not to be a novice situation. The character though may be similar, but points of conflicts even today in the contemporary times rests at the following points. Justiciability of the fundamental rights and the non-justiciable character of the DPSP. Moral obligation and duty casted upon the state to implement the directive principles as per Article 37 has also raised a serious point of contravention. Since the inception of the Constitution and Part 3 and Part 4. In numerous early cases, the Supreme Court ruled out that the directive principles could not supersede a fundamental right present in Part 3 of the Constitution. However, the position of the same became clear when the Supreme Court took a view in the case of State of Madras v. Srimati Champakam Dorai Rajan. In this case, the Supreme Court ruled that since fundamental rights are enforceable and directive principles are not, so the fundamental rights would prevail over the latter and have to run as subsidiary to the fundamental rights. However, the situation subsequently changed in 1967 by the Supreme Court itself in the case of I.C. Golkanath v. State of Punjab, whereby the Supreme Court held that the fundamental rights present in Part 3 of the Constitution are sacrosanct and thereby cannot be amended for implementation of the directive principles of state policy. Relationship between fundamental rights and directive principles of state policy. The relationship between Part 3 and Part 4 is the one that is not a novice one and was discussed by the constitutional advisor Sir B. N. Roy, who advocated the idea that the right of an individual on the basis of their nature can be divided into justiciable rights, non-justiciable rights. The list of justiciable rights was engulfed in Part 3 while the non-justiciable one became the member of Part 4 of the Constitution. At times and again these directive principles are used by the judiciary to determine the constitutional validity of any legislation when they are found to be in conflict with the fundamental rights or Part 3 of the Constitution. The first case we are going to discuss in this light is of Sajjan Singh v. State of Rajasthan of 1964, where the obiter dicta laid down by Justice Madhukar becomes apposite. Even the fundamental rights enshrined in Part 3 were taken as unalterable. The much-needed dynamism may be, according to him, achieved by a proper interpretation of the fundamental rights in light of the directive principles. Further, he observed that the Part 4 is fundamental in the governance of the country and the provision relating to Part 3 must be interpreted harmoniously with these principles. As discussed above in the case of Champakam Dorai Rajan, Supra, it was held by the Supreme Court that the fundamental rights would be reduced to a mere rope of sand if they were to be overridden or superseded by the directive principles of state policy. Also, as we discussed earlier in this article while deliberating on the case of I.C. Golkanath, Supra, Honorable Justice Subba Rao of the Apex Court accentuated that the fundamental rights and the directive principles of state policy together form an integrated scheme which is elastic enough to respond to the changing needs of the society. On a similar note, in Bijoya Cotton Mills v. State of West Bengal, the Supreme Court has two-folded view regarding the same. In a case of conflict between the rights of an individual and a law that particularly aims at the implementation of socio-economic policies in furtherance of the directive principles, the weight would be accorded to the latter. Every act or legislation enacted in fulfillment of the directive principles should be construed as the one professing in the public interest or as a reasonable restriction to Part 3 of the Constitution. Doctrine of harmonious construction and relevant case laws. The doctrine of harmonious construction as a new technique of interpretation was inducted and innovated by the Supreme Court in the case of Qureshi Mohg v. State of Bihar, where the court stated that the Constitution has to be construed harmoniously. The directive principles must be implemented in such a way that it does not take away or encroach upon the fundamental rights of citizens. The courts should adopt the principles of harmonious construction and attempt to give effect to both Part 3 and Part 4 of the Constitution. In Re. Kerala Education Bill case of 1958, Chief Justice S.R. Das held while affirming the primacy of fundamental rights over the directive principles, nevertheless, in determining the scope and ambit of fundamental rights relied upon by or on behalf of any person or body, the court may not entirely ignore the DPSPs laid down in Part 4 of the Constitution but should adopt the principle of harmonious construction and should attempt to give to both as far as possible. The Supreme Court then began to proclaim that there exists no conflict between the fundamental rights and directive principles, both stand supplementary and complementary to each other. The above stand was taken by the Apex Court in the case of Chandra Bhavan Boarding and Lodging v. State of Mysore. Since then, the Supreme Court of India in the plethora of cases started to reiterate the point that the judicial attitude towards both DPSPs and fundamental rights is co-equal. In 1973, In the landmark case of Keswananda Bharti v State of Kerala, Justice K.S. Hedge duly observed that the fundamental rights and directive principles constitute the conscience of the Constitution, while Justice Shalath and Grover observed that both these parts, 3 and 4, have to be balanced and harmonized. At various instances and in catena of cases, the courts have utilized the above-mentioned doctrine of harmonious constructions while pronouncing judgments relating to Part 3 and Part 4 of the Constitution. On a similar note, the Honorable Supreme Court in the case of State of Kerala v. N.M. Thomas held that both the directive principles and the fundamental rights should be construed in harmony with each other, and every effort should be made by respective courts to resolve any apparent inconsistency that exists between them. Justice Chandrachud in the landmark case of Minerva Mills v. Union of India observed, "Fundamental rights are not an end in themselves but are means to an end. The aforesaid end is specified in the directive principles." In the paras 56 and 57 of the same judgment, it was also duly held that harmony and balance between the fundamental rights and directive principles is an essential feature of the basic structure of the Constitution. From the above, one can lucidly infer that the fundamental rights enshrined in Part 3 can be considered to be the means to achieve several goals that are thereby enshrined in Part 4, and even at various instances the fundamental rights is interpreted in light of non-justiciable directive principles of state policy. The same becomes pertinent when we look in the case of Bandhu Mukti Morcha case, where the bench headed by Justice P.N. Bhagwati in page 163 of the same judgment has expressly mentioned the right to live human dignity, free from exploitation. Enshrined under Article 21 derives its life and breath from the directive principles of state policy, and particularly clauses E and F of Article 39 and Article 41 and 42. The inextricable and entangles relation between the Part 3, fundamental rights, and Part 4, directive principles of state policy, that was even recognized by the legislature in the 86th Constitutional Amendment Act of 2002, where right to education earlier and originally the element of Part 4 of the Constitution was raised to the fundamental right enshrined under Article 2(1) of Part 3 of the Constitution. These directive principles of state policy are fundamental in the governance of the country. They must be therefore regarded as equally fundamental to understanding and interpretation of the meaning and content of fundamental rights. The aforesaid view was taken by the Supreme Court in the case of Olga Tellis. Recently, in the case of Charu Khurrana v Union of India of 2015, the Supreme Court of India again highlighted the importance of their existence, Part 3 and Part 4, by observing that fundamental rights and the directive principles are the two wheels of the chariot establishing the egalitarian social order. In an overview, it becomes apparent or ostensible to note that the view of the judiciary regarding the relationship between the fundamental rights and the directive principles of state policy is the one that is subjected and have undergone gradual transformations from the case of 1951 of Srimati Champakam Dorairajan, where the Supreme Court accorded supremacy to the fundamental rights over the directive principles, to making the harmony and balance between the two, Part 3 and Part 4, an essential feature of the basic structure of the Constitution. Today, we can manifestly observe that Part 3 at times have to necessarily be interpreted in the light of the directive principles, and the codependence and liaison between the two are increasing day by day. Conclusively, It can be clearly inferred from the judgments as mentioned above that the approach of our judicial system towards the fundamental rights and directive principles have been an integrative one, and time and again, the judiciary in its judgment has employed the principle of harmonious construction. Question: explain briefly the brain drain by foreign education market. What is brain drain? Brain drain is a slang term that indicates a substantial immigration or migration of individuals. A brain drain can result from turmoil within a nation, the existence of favorable professional opportunities in other countries, or a desire to seek a higher standard of living. In addition to occurring geographically, brain drain may also occur at the organizational or industrial levels when workers perceive better pay, benefits, or upward mobility within another company or industry. Understanding brain drain. As noted above, brain drain is the movement of people from one area to another. Brain drain often occurs between countries and cities where they can find better opportunities. They may move to look for work or a better standard of living. Brain drain can also refer to the movement of professionals between corporations and/or industries for better pay or opportunities. Brain drain causes countries, industries, and organizations to lose a core portion of valuable individuals. The term is often used to describe the departure of certain professionals, including groups of doctors, healthcare workers, scientists, engineers, or financial professionals. When these people leave, the places they leave are harmed in two main ways. Expertise is lost with each immigrant, diminishing the supply of that profession. The country's economy is harmed because each professional represents surplus spending units. Professionals often earn large salaries, so their departure reduces consumer spending in that region or the country overall. Geographic, organizational, and industrial brain drain. Brain drain can occur on several levels: geographic, organizational, and industrial brain drain. Geographic brain drain. Geographic brain drain happens when talented professionals flee one country or region and end up moving to a country that they feel gives them better and more opportunities. Several common causes precipitate brain drain on the geographic level, including political instability, poor quality of life, limited access to healthcare, and a shortage of economic opportunity. These factors prompt skilled and talented workers to leave source countries for places that offer better opportunities. Organizational and industrial brain drain. Organizational brain drain involves the mass exodus of talented workers from a company, often because they sense instability, a lack of opportunity within the company, or they may feel that they can realize their career goals more easily at another company. Industrial brain drain happens when skilled workers exit not only a company but an entire industry. These two forms of brain drain are usually a byproduct of a rapidly evolving economic landscape in which companies and industries unable to keep up with technological and societal changes lose their best workers to those that can. Causes of brain drain. So what causes brain drain? As noted above, there are several underlying factors that lead to this phenomenon. They can vary, though, based on the type of brain drain. Some of the main reasons why people choose to leave their home countries' regions include economic opportunities, including new and better jobs, higher standards of living, access to housing and health care, political strife and instability, persecution based on religion, gender, or sexuality. While most brain drain is geographic, there is some brain drain that occurs as a result of situational factors. For instance, skilled workers may leave companies and industries when machines and technology replace human labor. Effects of brain drain. Brain drain can have major consequences. The effects are felt not only in the area where the brain drain occurs but also where the brain gain, where individuals move to, takes place. And it can often have a chain reaction. Areas affected by brain drain end up with a dearth of human capital. Professionals who go elsewhere end up leaving a large hole to fill, one that isn't always easy to fill. Consider medical professionals in developing nations who move to parts of the developed world for better opportunities. There may not be enough qualified people to replace them when they leave, which affects the quality of health care for those left behind. Another effect on areas that experience brain drain is the loss of revenue. Governments rely on income taxes to fund their social programs and infrastructure projects. A mass exodus leads to a drop in tax receipts, which can stunt economic growth and development. Areas that see brain gain are also impacted. Some of these factors include overcrowding, especially in major metropolitan areas where more opportunities are available. More people in one area puts a strain on resources, which can lead to higher prices and taxes. Measures to reduce brain drain. While there isn't an easy fix for brain drain, there are some things that business and government leaders can do to reduce or minimize it. These include increasing investments into certain areas of the economy, offering competitive wages, paving the way for legal and social reform, improving the quality of resources, such as housing and health care, providing affordable housing solutions. Examples of brain drain. Ukraine brain drain. War and conflict are big catalysts for brain drain. This was evident following Russia's invasion of Ukraine. Studies conducted by the European Parliament indicate a massive displacement of the country's population across the European Union, EU. One of the main areas the study examined was the movement of students. The number of students leaving Ukraine doubled from 25,000 to 50,000 between 2007 and 2014. That number jumped to about 78,000 by 2019. The majority of these students were enrolled in post-secondary institutions in Poland. Some professionals leaving Ukraine are having a tough time finding work in their fields in other countries because of a lack of available work or transferable skills. As such, some are choosing to take on lower-paying jobs to find a sense of security and safety. But it isn't just Ukraine that's experiencing a brain drain. In fact, Russia is experiencing a flight of human capital, too. Economic sanctions placed on the country by the US, the United Kingdom, and Canada are having a profound impact on Russian citizens. The federal government also has laws in place punishing citizens who support Ukraine. It's estimated that as many as 200,000 Russians left the country. Puerto Rico brain drain. Brain drain was a significant consequence of the ongoing Puerto Rican debt crisis as of 2019. This was particularly evident in the exodus of skilled medical professionals, which hit the island hard. While almost half of Puerto Rico's residents receive Medicare or Medicaid, the island receives significantly fewer federal funds to pay for these programs than similarly sized states on the mainland, such as Mississippi. This lack of funding combined with the island's dire financial situation precludes its ability to offer competitive compensation to doctors, nurses, and other medical staff. As a result, such professionals were reported to be leaving the island en masse for more lucrative opportunities on the mainland. This form of brain drain was also exacerbated by Hurricane Maria, which hit the island in September 2017, creating even more incentives for immigration. What does brain drain mean? Brain drain is a slang term that alludes to the loss of human capital from one area to another or from one industry to another. Brain drain usually happens when skilled individuals and professionals leave the home countries, in most cases, developing nations, and go elsewhere to take advantage of better opportunities. It also occurs when individuals leave one area of the workforce and go to another for some of the same reasons. How does economic growth help fight brain drain? Brain drain occurs when there is a lack of opportunity in a certain area. For instance, professionals living in a developing nation may leave in search of better opportunities in parts of the developed world. Making economic investments to boost growth often provides incentives for people to stay, as it means access to better, and more, resources, personal economic prosperity, and the potential for a higher standard of living. What impact does brain drain have on developing nations? Brain drain or the exodus of human capital often has a big impact on developing nations. It often leaves a hole that is hard to fill since there may not be as many people with similar skills to fill that void. It also leads to a loss in tax revenue, which can lead to higher taxation to make up for the shortfall. Citizens may not be able to access quality resources, such as education and healthcare, which also affects their quality of life. The bottom line. Human capital is a vital part of the economy. But when conditions get tough, these individuals may look elsewhere for better jobs, higher pay, and an improved standard of living. A mass exodus of people can lead to what's called brain drain. When human capital is depleted from a certain area, it can have lasting effects on the local economy. Question: explain the dichotomy between secularism vis-à-vis religious freedom. During the inception of the Constitution of India in 1950, the preamble did not contain the words socialist and secular. These words were added to the preamble through the 42nd Amendment Act in the year 1976. Prior to this amendment, the Supreme Court in Keshwananda Bharti v. State of Kerala held that preamble is a part of the Constitution and it can be amended but subject to the condition that the basic feature of the preamble cannot be amended. With the Bharatiya Janata Party coming to power in the year 2014, one word which is revolving in and around every person's mind is secular. Though prior to that, there were major changes that changed the demography of this country under the umbrella of secularism, but with a rise of a Hindu nationalist party, it is being alleged by the minority section of this country that their religion is under immense danger, and this has resulted in tremendous intolerance in the country. Analyzing the current scenario in the country, the research paper tries to portray the secularism existing in India in the light of the plight of millions of Hindus who have been the victim of this rising intolerance. The research paper concludes with certain suggestions which can be considered for establishing a balanced secular society and thus enshrining the goals of the Constitution. India is often accredited with the term melting pot of diversity, due to the presence of many religions within the country. In light of this religious diversity, independent India has proclaimed secularism to be one of its key policy values and thus declaring itself as a secular state by the insertion of the word secular in the preamble. D.E. Smith opines that a secular state is a state which guarantees individual and corporate freedom of religion, deals with the individual as a citizen irrespective of religion, is not constitutionally connected to a particular religion, nor does it seek either to promote or interfere with it. The secular state views its individual as a citizen and not as a member of a particular religious group. Religion becomes entirely irrelevant in defining the terms of citizenship. Its rights and duties are not affected by the individual religious beliefs. Article 25 of the Constitution of India allows any individual the freedom of conscience and free profession, practice and propagation of his/her religion. This article forms the bedrock of secularism in India. Accordingly, every person is allowed to practice his religion. The religious demography, before the advent of Islam, was to very extent stable, with only few religions residing. With the advent of Islam, not only a new community established but certain religions in order to counter this new religion of brotherhood also came into existence due to the growing atrocities against Hindus. This situation somewhat got stable with the coming of Britishers, but situation started deteriorating again with the divide and rule policy that was adopted by Britishers. After independence, the situation with regard to communal clashes started getting worsen. And with India entering the 21st century, the secularism in India started taking a different turn altogether. Though the beginning of this change started around 1990s with the enactment of Places of Worship Act in 1991 for prohibiting the conversion of any place of worship and requiring the preservation of any place of worship's religious character as it existed on 15 August 1947, and the demolition of Babri Masjid, which was allegedly to be constructed after demolishing the temple of Lord Ram. Prior to all these, from 1989 onwards, mass exodus of Kashmiri Pandits had begun from Kashmir. If one tries to analyze these incidents, prima facie appeared that the secularism in India for Hindus had become a hoax, and they were always subject to a situation of compromise. Year after year, the faith of Hindus was made a joke, and with the coming of Bharatiya Janata Party into power in 2014 and again in 2019, the faith of Hindu has been termed a new word, i.e. intolerance, by the liberal section of this country. Secularism in India. The Hindu ethos is prevalent in India. Hindus make up the bulk of the population. It is ingrained in the culture to respect all forms of thinking, belief, and worship. Minority sects would have had complete equality even though the constitutional protections had not been in place. This is in contrast to our Muslim majority neighbors Pakistan, Bangladesh, Afghanistan, and the Middle East's Iran, Iraq, Jordan, Saudi Arabia, and others have proclaimed themselves Islamic republics or kingdoms and have refused Hindus religious freedom by law and practice. If one tries to trace the incidents from the time Islamic invaders invaded India and especially after the independence, it appears that under the Islamic rule, the religious sentiments of the Hindus became the victim of the aggressive conversion policies of the Islamic rulers. Thousands of temples, including certain temples of utmost importance in the Hindu religion such as at Ayodhya, Kashi, Mathura, Somnath and many others were attacked and illegally demolished, and at certain demolished sites, mosques were even constructed. What surprises the most is the situation which supposed to have improved, worsened after independence. Minor incidents of temples being demolished and lynching of Hindus were reported from various parts of the country. Post-independence, it was in 1976, the Indira Gandhi government decided to insert the word secular to the preamble, which was left out by the constitution makers. But one prominent question arises after this amendment, i.e. did the insertion of secular implied that India had not been secular before 1976. Had the omission of the word turned India into a Hindu Rashtra? The answer to these questions is no. The fathers of the constitution made it incumbent on Hindus to note their devotion to the Upanishadic ideal of Vasudhaiva Kutumbakam, by leaving the term out of the preamble. So, secularism in the Indian context would not mean the state remaining away from religion. Instead, it would mean maintaining equidistance from all religions. Unfortunately, that equidistance never happened. Over the years, the test of secularism came to be whether India's minorities perceived an action as secular or not. For example, the government gave itself very little day-to-day control over the Central Waqf Council or over Christian institutions, but soon exercised incredible control over Hindu temples. Nehru decided to pass the 4 Hindu code bills while abandoning the objective of a uniform civil code. Even in politics, seeking Muslim votes by appealing to the Imam of Jama Masjid was considered smart, but appealing to Hindu seers was communal. Religious interference and temple destruction. The repeated aggressions of radical Islamists and Christians has pushed the Hindus into a state of victimhood. Continuous assault over the religious sentiments of the Hindus has not only destroyed the thread of unity among Hindus but also destruction of thousands of temples. The history is full of such incidents of destruction of temples. For example, the Somnath temple. The temple was first desecrated in 725 CE by Al-Junayd, the Arab governor of Sindh. After being repaired, it was destroyed during Mahmud of Ghazni's invasions in 1025. It was repaired, but Alauddin Khilji destroyed it again in 1299. The temple was rebuilt only to be demolished in 1395 by Zafar Khan, the Muslim governor of Gujarat. The Sultan of Gujarat, Mahmud Bigda, desecrated it in 1451. In 1665, Aurangzeb dealt the final blow when he tore it down. Such incident of demolition of temples can also be found in the 3 holy sites of Ayodhya, Mathura and Kashi. Fortunately, the dispute in Ayodhya took a legal turn and was instituted in the court as a suit which took years to be resolved. In 1992, the Babri Masjid, which was built over the Ranjanmabhoomi, was demolished by Hindus. Fortunately, another title suit was instituted in the court, and in 2019, the apex court granted the disputed site to Hindus. Though the Ayodhya dispute has been resolved, Mathura and Kashi are still waiting to get justice. The beginning of construction of Ram Temple at Ayodhya also faced backlash from the secular group of the country for not constructing hospitals or other public infrastructure. But such criticisms were not made while construction of mosques in different parts of the country. Apart from these prime religious sites, today also, idols of Hindu gods and goddesses are destroyed and religious sites are being desecrated by people from minority groups. In addition to this, despite constitutional provisions, state governments have been regulating and regularly taking over Hindu temples, while mosques and churches are permitted to be governed exclusively by their respective communities, despite Article 26 conferring the right on all people equally. Furthermore, state control of temples is doubly harmful to Hindus in that they have not only lost control of their temples to the government, but they have also become a part of the state, as per Article 12 of the Constitution, as a result of that control. As a result, centuries-old religious rituals, festivals, and traditions are selectively and unduly questioned and interfered with. In addition to this, in 1991, the P.V. Narasimha Rao government enacted the Places of Worship Act, in the backdrop of growing agitation by right-wing groups regarding reclamation of 3,000 mosques which were built by destructing temples. The act aims to freeze the status of places of worship as they were on 15 August 1947. The law kept the disputed structure at Ayodhya out of its purview, mainly because it was the subject of prolonged litigation. It was also aimed at providing scope for a possible negotiated settlement. This law again hurt the religious sentiments of the majority population, because in the name of secularism, the mosques were given a security from being demolished, as history is full of examples, where temples have been demolished and mosques have been built over them. Human rights violations. Gross human rights violation has been taking place from the day Islamic invaders came to India. In the name of conversion, several people were looted and killed and women were raped. During the British Raj, due to the divide and rule policies, there were constant communal clashes. In post-independent India, these clashes exaggerated further, and the primary victim of this exaggeration were the Hindus. Mob lynching cases were reported from all over the country. But something more severe took place in the 1990s. In 1990, India saw one of the largest exoduses of a community fleeing its homeland from fear of being persecuted. 5. The number of people who fled remains debated, with few authors stating it ranged from 1 lakh to 1,40,000 to as high as 800,000. 6. Religious and ethnic triggers, as well as external influences, seem to have played a role in the incident. The Hindu community was disappointed, believing that they were not treated fairly because they were a minority. Many factors contributed to Hindu-Muslim tensions, including the construction of a mosque on the Secretariat grounds. This attracted the resentment of many Hindus. As a result, several temples were demolished, including those in Anantnag, causing widespread havoc. The genocide that began in the valley was targeted towards the minority community residing there, i.e. the Kashmiri Pandits, and the primary reason is that these people follow a particular religion. Thousands of people were made refugees in their own country, many were looted and killed, and women were raped. But unfortunately, there was no crackdown on these gross human rights violations. Hopefully, the abrogation of Article 370 and 35-A has started attracting the Pandits back to the valley. In 21st century, mob lynching of Hindus and no action against the culprits has become a daily affair of the country. Whether it is the Palghar lynching case, or lynching of common people in the name of conversion, the government has become a mute spectator. What is surprising is Hindus are being lynched just because of supporting a particular party. The state of West Bengal is reporting such incidents in large numbers, where the goons of the ruling TMC government are killing supporters of the BJP. The post-poll violence appeared genocidal-like situation where these goons not only killed BJP workers but also damaged properties and also assaulted and raped women. The prime target of these incidents of violence were Hindus just because of following a political party with a Hindu ideology and religion. The issue of love jihad has also become a center of discussion. Many Hindu women are lured to marry by the men from other religion and after marriage are forced to convert to the religion of their husband. The refusal to convert brings torture and at times death for the women. Such incidents have been termed as love jihad by the Hindu right-wing groups. States like Uttar Pradesh, Madhya Pradesh and Uttarakhand have enacted laws to curb such incidents of love jihad. Such laws have been termed by critics as against the fundamental rights of citizens, especially Article 25. But the fact is, women not only from Hindu religion but also from other religion are lured to marry, later are forced to convert, and if the women refuse, she is assaulted and at times killed. However, most of the victims are from Hindu religion. During such incidents where a woman from the majority population is the victim, none of the human rights activists come out in support of such victims. Hopefully, the love jihad laws would be helpful in curbing such cases with regard to women from all the religion. Appeasement politics. The nation's political parties have passionately opposed to the secular state's strategy. They combine religion with revenge in politics and toss ideals into the open. Religion is nothing more than a dead ritual if it lacks ideals such as justice, equality, compassion, love, non-violence, truth, and sensitivity to other people's suffering, and it can be very dangerous if faith is synonymous with hollow rituals rather than beliefs, as our politicians do. This has been the case since the country's independence. The Indian politics has been commercialized. Politicians, rather than focusing on achievements, focus more on branding themselves with religious groups which are considered as the dominant religious groups in the region. This branding is termed as appeasement politics. Whether it be the regional parties or national parties, minority appeasement is the first method to grab votes. Post-independence, every election has seen appeasement of minority religions. Be it granting monthly salary to imams or welfare projects for minority groups or trips to Hajj, the welfare of Hindus during these appeasement politics is the last thing done. A recent example is during the election of the state of West Bengal. The TMC government increased the salary of imams, offered namaz, and did what not to appease the minority sections which form a good chunk of the state's population. However, seeing the BJP conducting an aggressive campaigning through its top leaders for grabbing votes of Hindus, the TMC Supremo Mamata Banerjee turned herself towards appeasing the Hindus by performing Chandi Path. Similar instances of appeasing Hindus just before election has been done by several other chief ministers by arranging Tirth Yatras programs just before elections. The Prime Minister himself had offered scholarships for students from minority community. Conclusions and suggestion. Every invasion of India by an alien religious and cultural community, according to Gajendra Ducker, J., resulted in conflicts and forcible conversion for a short period of time. But, in the end, they settled down peacefully and contributed to the Indian society in different ways. This, he says, is due to the Hindu religion's omnipresence of tolerance and liberal nature, which provides the theological foundation for the philosophy of secularism in India. India's constitutional scheme guarantees equality in matters of religion to all religions, to all persons and classes, regardless of faith, emphasizing that the state has no religion. The preamble of the Constitution, when read in conjunction with Articles 25 to 28, exemplifies this point and shows that secularism is enshrined in our Constitution in this way. With the Bharatiya Janata Party coming into the power, the Hindus found a ray of hope for raising their voices and to some extent even did. But the liberals of this nation termed this as religious intolerance towards minority communities. A new trend has emerged that whatever the ruling government does, it is for Hindus and only they should be blamed for it. Due to this, for every act of government, the common Hindu mass is being abused who has no role to play in the acts of government. There is a strong need to curb this growing aggression against the Hindus and achieve the goals of secularism as enshrined in the Constitution. The first and foremost thing is to bring a uniform civil code. This will provide a basic foundation to reorient the policy of secularism, as there would be a singular law for civil purposes such as marriages, adoption, etc. instead of numerous personal laws. Secondly, there should be a curb over the appeasement politics. Political parties focus more on appeasing the religions which are dominant in a particular region. This is despite the ruling of the Apex Court in S.R. Bomai v. 7, wherein the court states that political parties or the group of individuals who aspire to hold public posts must abide by the provisions of the Constitution. They should not mix religion with politics and respect the fundamental of secularism. The policies of the government should be focusing on particular religion but on the population as a whole. Thirdly, a committee should be formulated independent of political interference to look into the matters of mob lynching and human rights violations, including the cases of love jihad, and ensure that such cases exclusively investigated by the CBI. Lastly, restoration of temples and allotment of alternate sites to Muslims for construction of their mosques and allow them to profess their faith peacefully. In the end, the words of Shashi Tharoor are worth mentioning to understand the Indian secularism. He says, Western dictionaries define secularism as absence of religion, but Indian secularism does not mean irreligiousness. It means profusion of religions. Question: explain doctrine of separation of powers. Legislative power. Congress as the sole power to legislate for the United States. Under the non-delegation doctrine, Congress may not delegate its law-making responsibilities to any other agency. In this vein, the Supreme Court held in the 1998 case Clinton v. City of New York that Congress could not delegate a line-item vote to the President, by which he was empowered to selectively nullify certain provisions of a bill before signing it. The Constitution Article I, Section 8, says to give all the power to Congress. Congress has the exclusive power to legislate, to make law, and in addition to the enumerated powers it has all other powers vested in the government by the Constitution. Where Congress does not make great and sweeping delegations of its authority, the Supreme Court has been less stringent. One of the earliest cases involving the exact limits of non-delegation was Wayman v. Soithard, 1825. Congress had delegated to the courts the power to prescribe judicial procedure. It was contended that Congress had thereby unconstitutionally clothed the judiciary with legislative powers. Executive power. Executive power is vested, with exceptions and qualifications, in the President by Article 2, Section 1, of the Constitution. By law the President becomes the Commander-in-Chief of the Army and Navy, militia of several states when called into service, has power to make treaties and appointments to office with the advice and consent of the Senate, receive ambassadors and public ministers, and take care that the laws be faithfully executed. Section 3. By using these words, the Constitution does not require the President to personally enforce the law. Rather, officers subordinate to the President may perform such duties. The Constitution empowers the President to ensure the faithful execution of the laws made by Congress. Congress may itself terminate such appointments, by impeachment, and restrict the President. The President's responsibility is to execute whatever instructions he is given by the Congress. Congress often writes legislation to restrain executive officials to the performance of their duties, as authorized by the laws Congress passes. In Ins v. Chaya, 1983, the Supreme Court decided, the prescription for legislative action in Article I, Section 1 requiring all legislative powers to be vested in a Congress consisting of a Senate and a House of Representatives, and Section 7 requiring every bill passed by the House and Senate, before becoming law, to be presented to the President, and, if he disapproves, to be repassed by 2/3 of the Senate and House represents the framers' decision that the legislative power of the federal government be exercised in accord with a single, finely wrought and exhaustively considered procedure. This procedure is an integral part of the constitutional design for the separation of powers. Further rulings clarified the case. Even both houses acting together cannot override executive vetoes without a second-march majority. Legislation may always prescribe regulations governing executive officers. Judicial power. Judicial power. The power to decide cases and controversies is vested in the Supreme Court and inferior courts established by Congress. The judges must be appointed by the President with the advice and consent of the Senate, hold office for life and receive compensations that may not be diminished during their continuance in office. If a court's judges do not have such attributes, the court may not exercise the judicial power of the United States. Courts exercising the judicial power are called constitutional courts. Congress may establish legislative courts, which do not take the form of judicial agencies or commissions, whose members do not have the same security of tenure or compensation as the constitutional court judges. Legislative courts may not exercise the judicial power of the United States. In Maurice Lessee v. Hoboken Land and Improvement Co., 1856, the Supreme Court held that a legislative court may not decide a suit at the common law, or in equity, or admiralty, as such a suit is inherently judicial. Legislative courts may only adjudicate public rights. Even though above all, separation of powers is not accepted in American in its strict sense, only it has attracted the makers of most modern constitution, especially during 19th century. In a leading case, Marbury v. Madison, is a landmark case in United States law. It is formed the basis for the exercise of judicial review in the United States under Article 3 of the Constitution. This case resulted from a petition to the Supreme Court by William Marbury, who had been appointed by President John Adams as Justice of the Peace in the District of Columbia but whose commission was not subsequently delivered. Marbury petitioned the Supreme Court to force Secretary of State James Madison to deliver the document, but the court, with John Marshall as Chief Justice, denied Marbury's petition, holding that the part of the statute upon which he based his claim, the Judiciary Act of 1789, was unconstitutional. Marbury v. Madison was the first time the Supreme Court declared something unconstitutional, and established the concept of judicial review in the U.S., the idea that courts may oversee and nullify the actions of another branch of government. The landmark decision helped define the checks and balances of the American form of government. Separation of powers has again become a current issue of some controversy concerning debates about judicial independence and political efforts in increase the accountability of judges for the quality of their work, avoiding conflicts of interest, and charges that some judges allegedly disregard procedural rules, statutes, and higher court precedents. It is said on one side of this debate the separation of powers means that powers are shared among different branches. No one branch may act unilaterally on issues, but most obtain some form of agreement across branches. That is, it is argued that checks and balances apply to the judicial branch as well as to the other branches. It is said on the other side of this debate the separation of powers means that the judiciary is independent and untouchable within the judiciary's sphere. In this view, separation of powers means that the judiciary alone holds all powers relative to the judicial function, and that the legislative and executive branches may nor interfere in any aspect of the judicial branch. The doctrine of separation finds its home in U.S. It forms the basis of the American constitutional structure. Article I vests the legislative power in the Congress, Article 2 vests executive power in the President, and Article 3 vests judicial power in the Supreme Court. The framers of the American Constitution believed that the principle of separation of powers would help to prevent the rise of tyrannical government by making it impossible for a single group of persons to exercise too much power. Accordingly, they intended that the balance of power should be attained by checks and balances between separate organs of the government. This alternative system existing with the separation of prevents any organ to become supreme. Despite of the express mention of this doctrine in the Constitution, U.S. incorporates certain exceptions to the principle of separation with a view to introduce system of checks and balances. For example, a bill passed by the Congress may be vetoed by the President in the exercise of his legislative power. Also, treaty-making power is with the President, but it's not effective till approved by the Senate. It was the exercise of executive power of the Senate due to which U.S. couldn't become a member to League of Nations. The Supreme Court has the power to declare the acts passed by the Congress as unconstitutional. There are other functions of an organ also which are exercised by the other. India, too, followed U.S. in adoption of the checks and balances which make sure that the individual's organs doesn't behold the powers absolutely. This means that functioning of one organ is checked by the other to an extent so that no organ may misuse the power. Therefore, the Constitution, which gives a good mention of the doctrine in its provisions, also does not follow it in its rigidity and hence has opted for dilution of powers just like India. Separation of powers and the Indian Constitution. The constitutional history of India reveals that the framers of the Indian Constitution had no sympathy with the doctrine. This is evident from its express rejection in spite of attempts being made. It even sheds no light to the application of the doctrine during the British regime. The Constituent Assembly, while in the process of drafting the Constitution, had dwelt at length for incorporating the doctrine and ultimately rejected the idea in toto. Dr. Ambedkar, who was one among the members of the Constituent Assembly, while comparing the parliamentary and presidential systems of India and America respectively, remarked as thus: looking at it from the point of view of responsibility, a non-parliamentary executive, being independent of parliament, tends to be less responsible to the legislature, while a parliamentary system differs from a non-parliamentary system in as much as the former is more responsible than the latter, but they also differ as to time and agency for assessment of their responsibility. Under the non-parliamentary system, such as the one exists in USA, the assessment of the responsibility of the executive is periodic. It takes place once in 2 years. It is done by the electorate in England, where the parliamentary system prevails. The assessment of responsibility is both periodic and daily. The daily assessment is done by the members of the parliament through questions, resolutions, no confidence motions, adjournment motions and debates on address. Periodic assessment is done by the electorate at the time of the election, which may take place every 5 years or earlier. The daily assessment of responsibility which is not available under the American system is, it is felt, far more effective than the periodic assessment and far more necessary in a country like India. The draft constitution, in recommending the parliamentary system of government, has preferred more responsibility than stability. The above view of Dr. Ambedkar thus substantiates that Indian constitution does not make any absolute or rigid separation of powers of three organs owing to its pro-responsibility approach rather than having stability at the center stage. This has, however, been further supplemented and reiterated by the Indian Supreme Court. In Ram Javaya Kapoor v. State of Punjab, the court though Mukherjee J held that the Indian constitution has indeed not recognized the doctrine of separation of powers in its absolute rigidity, but the functions of different parts or branches of the government have been sufficiently differentiated, and consequently it can very well be said that our constitution does not contemplate assumption, by one organ or part of the state, of functions that essentially belong to another. A more refined and clarified view taken in Ram Javaya's case can be found in Qatar Singh v. State of Punjab, where Ramaswamy J stated, "It is the basic postulate under the Indian constitution that the legal sovereign power has been distributed between the legislature to make the law, the executive to implement the law, and the judiciary to interpret the law within the limits set down by the Constitution. The functional classification and sufficient demarcation, as is held by the Supreme Court, indeed does not suggest the application of the doctrine in its absolute terms. Rather it just gives a slight glimpse as to the character of the Indian constitution which it shares with the pure doctrine discussed above, that is, inter alia the acceptance of the philosophy behind the doctrine pertaining to rigors of concentration of power and the avoidance of tyranny, of having a rule of law and not rule of men. The same can be substantiated through a detailed analysis of the provisions of the Constitution, which is the next course of action this chapter attempts to take. Executive in India, like any other Westminster system, is a subset of legislature, and virtually there is a fusion between them, thus generally no friction arises between them. The Constitution of India has indeed adopted the British parliamentary system, wherein the political executive controls the parliament. In addition, the cabinet or the council of ministers enjoys a majority in the legislatures and virtually control both the legislature as well as the executive. Just like the British cabinet, its Indian counterpart can be called as OEA-, which joins a buckle which the legislative part of the state to its executive part. Under the Indian constitution, the executive powers are vested with the president and governors for respective states. The president is, therefore, regarded as the chief executive of Indian Union who exercises his powers as per the constitutional mandate on the aid and advice of the Council of Ministers. The President is also empowered to promulgate ordinances in exercise his extensive legislative powers which extend to all matters that are within the legislative competence of the Parliament. Such a power is extensive with the legislative power of the Parliament. Apart from ordinance making, he is also vested with powers to frame rules and regulations relating to the service matters. In the absence of parliamentary enactments, these rules and regulations hold the field and regulate the entire course of public service under the Union and the states. Promulgation of emergency is emergent situations is yet another sphere of legislative power which the President is clothed with. While exercising the power after the promulgation of emergency, he can make laws for the state after the dissolution of state legislature following the declaration of emergency in a particular state, on failure of the constitutional machinery. Like the British Crown, the President of India is a part of the legislature, though he is not a member of any house of the Parliament. No bill for the formation of new states or alternation of boundaries etc. of the existing states, or affecting taxation in which states are interested, or affecting the principles laid down for distributing money to the states or imposing a surcharge for the purposes of the Union, and no money bill or bill involving expenditure from the Consolidated Fund of India can be introduced for legislation except on the recommendation of the President. Besides this, he also has powers to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted any offence which is of judicial nature. He also performs similar judicial functions in deciding a dispute relating to the age of the judges of the constitutional courts for the purpose of their retirement from their judicial office. In a similar manner, Parliament also exercises judicial functions. While performing judicial functions, it can decide the question of breach of its privilege and, if proved, can punish the person concerned. While doing so, the Parliament is the sole judge and courts cannot generally question the decision of the Houses on this point. Moreover, in case of impeachment of the President, one house of the Parliament acts as a prosecutor and the other house investigates the levelled charges and decides whether they substantiate or not. There is, however, a considerable institutional separation between the judiciary and other organs of the government. The Constitutional confers wide powers, however. A certain amount of executive control is vested in the higher judiciary with respect to subordinate judiciary. At the same time, the power of appointment of high courts and Supreme Court judges, including the Chief Justice of India, vests partially with the executive, that is to say, the President of India, who in turn exercises this power in consultation with the governors of the concerned states and the Chief Justice of the concerned High Court in case of a High Court judge and Chief Justice of India in case of a Supreme Court judge. Moreover, the judges of constitutional courts cannot be removed except for proved misconduct or incapacity, and unless an address supported by 2/3 of the members and absolute majority of the total membership of the House is passed in each House of the Parliament and presented to the President. Apart from exercising routine judicial functions, the Superior Constitutional Courts also performs certain executive and administrative functions as well. High courts have supervisory powers over all subordinate courts and tribunals and also the power to transfer cases. In addition, the high courts as well as the Supreme Court also have legislative powers by virtue of which they can frame rules regulating their own procedure for the conduct and disposal of cases. The foregoing exercise establishes the proposition expounded by the Supreme Court in Ram Javai's case. The analysis clearly shows that the concept of separation of powers, so far as the Indian Constitution is concerned, reveals an artistic blend and an adroit admixture of judicial, legislative and executive functions. Separation sought to be achieved by Indian Constitution is not in an absolute or literal sense. Despite being evident that the Constitution nowhere expressly bows in line to the concept, albeit it remains an essential framework of the constitutional scheme. Agreeing on this premise, it has also been accorded the status of basic structure by the Supreme Court. Therefore, it can axiomatically be said that Indian Constitution does not contemplate separation as embodied in the pure doctrine, it rather perceives and accords to it in its central sense, that is to say, not in its literal sense, rather in its purposive sense, i.e. non-conferment of unfettered powers in a single body of men and to motivate checks and balances. Another point of concern which requires clarification is whether the three organs, though not rigidly separate, can usurp their powers or are they required by the Constitution to work only within the respective area earmarked in a narrow sense. To put it differently, whether the Constitution mandates encroachment by one organ into the domain of another on the pretext of failure or inaction of the other organ is the next question that needs to be addressed in its context. Though theoretically, this issue has been addressed by the Supreme Court, however, it has failed to cater basis in practice, which is evident from the growing amount of judicial encroachment in the domain of other organs. In Asif Hamid v. State of J&K, it has been held that although the doctrine of separation of powers has not been recognized under the Constitution, makers have meticulously defined the functions of various organs of the state. Legislative, executive and judiciary have to function within their respective spheres demarcated under the Constitution. No organ can usurp the functions assigned to another. Legislative and executive organs, the two facets of the people's will, have all the powers including that of finance. Judiciary has no power over sword or the purse. Nonetheless, it has power to ensure that the aforesaid two main organs of the state function within the constitutional limits. It is the sentinel of democracy. The prime point of our concern here is whether the judicial organ of the state is conferred with a constitutional mandate so as to overstep its limits while discharging its main functions. That is to say, whether the judiciary can interfere and encroach in the executive or legislative domain if just demands so, or it cannot do so simply by virtue of the fact that the concept of separation of powers puts fetters on it. To answer these points, one need to ascertain as to what statute the judiciary has been accorded in the Indian constitutional. Is it supreme as compared to the other organs or is subordinate thereto? Judiciary under Indian Constitution has been given an independent status. It has been assigned the role of an independent umpire to guard the Constitution and thereby ensure that other branches may not exceed their powers and function within the constitutional framework. Commenting and clarifying the concept of independence of judiciary, Sir A.K. Iyer, who was one of the framers of the Constitution, had observed that the doctrine of independence of judiciary is not to be raised to a level of a dogma so as to enable the judiciary to function as a kind of super-legislature or super-executive. The judiciary is there to interpret the Constitution or to adjudicate upon the rights between the parties concerned. It can thus very aptly be said that creation of judicial organ in India was not at all meant to give to it a supreme status as compared to the other co-ordinate organs. Rather, with powers and functions sufficiently distinguished and demarcated, what is expected out of judiciary is to act as a watchdog to oversee and prods to keep the other organs within the constitutional bounds. The essence of the Constitution is that it produces a system which is the result of amalgamation of the principles of separation of powers with the doctrine of parliamentary sovereignty in a manner to give effect to both, yet without the rigidity of the two systems. The parliamentary democracy is cemented as the cornerstone of constitutional edifice in preference to the presidential system of governance. Separation of powers and judicial pronouncements in India. In India, we follow a separation of functions and not of powers. And hence, we don't abide by the principle in its rigidity. An example of it can be seen in the exercise of functions by the cabinet ministers, who exercise both legislative and executive functions. Art. 74, 1. wins them an upper hand over the executive by making their aid and advice mandatory for the formal head. The executive, thus, is derived from the legislature and is dependent on it for its legitimacy. This was the observation made by the Honorable SC in Ram Javaya v. Punjab. On the question that where the amending power of the Parliament does lies and whether Art. 368 confers an unlimited amending power on Parliament, the SC in Keshwanand Bharti held that amending power was now subject to the basic features of the Constitution, and hence, any amendment tapering these essential features will be struck down as unconstitutional. Beg. J added that separation of powers is a part of the basic structure of Constitution. None of the three separate organs of the Republic can take over the functions assigned to the other. The scheme cannot be changed even by resorting to Art. 368 of the Constitution. There are attempts made to dilute the principle to the level of usurpation of judicial power by the legislature. In a subsequent case law, SC had occasion to apply the Keshwanand ruling regarding the non-amendability of the basic features of the Constitution, and strict adherence to doctrine of separation of powers can be seen in Indira Nehru Gandhi v. Rajnarayan, where the dispute regarding PM election was pending before the Supreme Court. It was held that adjudication of a specific dispute is a judicial function which Parliament, even under constitutional amending power, cannot exercise power. So, the main ground on which the amendment was held ultra vires was that when the constituent body declared that the election of PM won't be void, it discharged a judicial function which according to the principle of separation it shouldn't have done. The place of this doctrine in India context was made a bit clearer after this judgment. Though in India strict separation of powers like in American sense is not followed, but the principle of checks and balances a part of this basic structure doctrine, so much so that not even by amending the Constitution, and if any such amendment is made, the court will strike it down as unconstitutional. Question. Discuss about the use of observation method. The observation method is a process that involves human or mechanical observation to observe and describe the behavior of a subject. As the name suggests, observational research is a way of collecting relevant information and data by involves observing people's behavior. The observational research method is also referred to as a participatory study because the researcher has to establish a link with the respondent and for this has to immerse himself in the same setting as theirs. Only then can he use the observational research method to record and take notes. Meaning and examples. Observational research is used in cases where you want to avoid an error that can be a result of bias during evaluation and interpretation processes. Observational research is one of the many other research methods to obtain objective data by watching a participant and recording it for analysis at a later stage. A researcher can use observational research, for example in a school, and record the behavior of the children at a young age. Are the children comfortable sharing their tiffin at such an early age will make a good study for the researcher. In this example, the researcher can observe and record the details objectively. The observational research data collection method is associated with observational research methods but with a few ethical issues as it needs the full consent of a research participant. The observation method in data collection can be structured observation method. Structured observation is a systematic observation method where data is collected as per a predefined schedule. The specific variable is used in this observation data collection method. Unstructured observation method. The unstructured observation method is different from structured observation because it is conducted in a free and open manner without using any predetermined objectives, schedules, or variables. While conducting observational research, the researcher has a vital role to play in collecting data, as he will have to collect, record and classify the data appropriately. The research method's primary sampling methods are event sampling. In the event sampling observation method, the researcher decides beforehand what events or behavior he will record and which ones he is going to ignore. Time sampling. In the time sampling observation method, the researcher chooses the time when he will observe. He makes a record of the occurrence only in the specified and predetermined period. Target time or instantaneous sampling. In the target time or instantaneous sampling observation method, the researcher decides beforehand the moments when the observation will happen and will be recorded at that moment. Everything that happens before or after that moment is of no consequence and hence is typically ignored. Types of observational research methods. The different types of observation methods in observational research are as follows. 1. Controlled observations. The controlled observation is carried out in a closed space. It is the researcher who has the authority to decide the place and the time where and when the observation will take place. He also decides who the participants will be and in what circumstances will he use the standardized process. The participants are chosen for a variable group randomly. The researcher observes and records a detailed and descriptive quantitative data of behavior and divides it into a distinct category. Sometimes the researcher codes the action as per an agreed scale by using a behavior schedule. The coding can include letters or numbers or a range to measure behavior intensity and describe its characteristics. The collected data from observational research methods is often turned into statistics for laboratory research. In a controlled observation method, the participants are informed by the researcher about the aim of the research. This makes them aware of being observed. The researcher avoids direct contact during the observation method and generally uses a two-way mirror to observe and record details. Advantages of controlled observation method. 1. The data and information received from a controlled observation method are structured and analytical. It is thus easy to analyze it quickly and is considered less time-consuming than the other observation methods. 2. Other researchers can easily replicate the report that has been created through the controlled observation method. They use a similar observation schedule, and this makes it easy to test for reliability. 3. As the controlled observation method is several quick observations can be conducted within a short time frame. Thus the researcher can collect large samples, which makes it easier for him to generalize a large population. Limitations of controlled observation method. 1. The controlled observation method lacks validity because when the participants are aware of being observed, their behavior will automatically change. 2. Naturalistic observations. Social scientists and psychologists generally use the naturalistic observation method in observational research studies. The process of naturalistic observation involves observing and studying the spontaneous behavior of the participants in open or natural surroundings. The role of the researcher is to find and record whatever he can see and observe in natural habitat. Advantages of naturalistic observation method. 1. When a participant is in a natural habitat, his flow of behavior is natural and not forced. 2. Naturalistic observation studies have gained better ecological validity than the controlled observation method. 3. The naturalistic observation method is used by the researchers to create new ideas. The researcher has the chance to observe the total situation and can find avenues that other people have not thought about. Limitations of naturalistic observation methods. 1. The naturalistic observation method facilitates observations on a microscale. It often lacks a representative sample and thus cannot help the researcher in making a generalization that relates to a broader society. 2. In naturalistic observation, the researcher needs proper training to recognize aspects that are significant and worth attention. 3. The observations through naturalistic observation method are not as reliable as the researcher wants them to be because it is not possible to control some variables. This is why other researchers cannot similarly repeat the study or research. 4. Establishing the cause and effect relationship is not possible because the researcher cannot manipulate the variables. 3. Participant observation. The participant observation method is often considered a variant of the naturalistic observation method because it has some similarities with it. The point of difference, called disguised naturalistic observation, is that the researcher is not a distant observer anymore because he has joined the participants and become a part of their group. He does this to get a more in-depth and greater insight into their lives. In participant observation, the researcher interacts with other members of the group freely, participates in their activities, studies their behavior, and acquires a different way of life. Participant observation can be overt or covert. 1. Overt participant observation. When the researcher asks permission from a group to mingle, the observation method is known as overt. He does so by revealing his true purpose and real identity to the group with whom he wants to mingle. 2. Covert participant observation. When the researcher does not show either his true identity or real meaning to the group he wants to join, then the observation is known as covert. He keeps both concealed and takes on a false role and identity to enter and mingle in the group. He generally acts as if he is a genuine member of that group. Advantages of participant observation methods. 1. It is easy to study and observe the natural behavior of the participants in the group by becoming a part of that group. The respondents generally do not know that they are being observed and behavior recorded, so they are not restrained or constrained in their activities and behavior. 2. The researcher becomes understanding by following the events of the respondents from such a close angle. 3. During the participant observation method, the researcher develops a good and healthy relationship with the respondents. This rapport helps him to participate in all the activities and make observations with a detached mind. 4. The participant observation method helps the research to observe the actual behavior of the respondents and create an inclusive and intensive case study of that group. 5. Actual participation in the activities provides the researcher with an opportunity to converse freely with other members about various events, their meaning and their importance to them. He gains an in-depth knowledge which would not have been possible only by observation. Limitations of participant observation methods. 1. It is challenging to work undercover. For example, the researcher will have only to observe and not record in front of others because he will not want to blow his cover. He relies heavily on his memory, which can be faulty at times. 2. Sometimes the researcher becomes too involved in the intricacies of that group. There is a higher chance of losing his objectivity because his reporting will be selective and dependent on his memory. 3. The emotional participation of the researcher can result in bias interpretation. He will be influenced to some degree, and a time might come when he would start supporting them unconditionally because their views and behavior will ultimately become his. This will result in a personal viewpoint of the scenario and not an objective or scientific report. 4. In the participant observation method, the researcher's experience becomes intense because of his proximity to the group members, but the range becomes limited. 5. The researcher misses many vital points because of his familiarity. 6. Proximity with the group will involve him in group factionalism, and he will have to take sides. He then loses his objectivity as an impartial observer with whom everyone is ready to cooperate. Advantages of the observation method. Provides direct access to research phenomena. By observing firsthand, the researcher can collect, check and record accurate data. Greater flexibility in terms of application. Generate a permanent record of phenomena and the researcher or others can refer with it later. The organization method is one of the simplest methods of data collection. It does not require too much technical knowledge. The observation method is one of the best ways to formulate a hypothesis. The researcher can observe and come to know about the activities, perceptions, likes, and dislikes to form a theory on his subject. Observational methods are one of the most common methods used in all sciences and is very easy to follow and accept. In some instances, observation is the only available tool to collect essential data and information. The observation method does not require the willingness of the participant to record. The researcher can observe from a distance and record his findings. Disadvantages of the observation method. Observational methods face a severe disadvantage because it takes a longer time frame compared to other data collection methods. There is a chance of higher observer bias in the observation method. Several personal behaviors are not open for observation, and this proves a limitation in case of observation method. There is a higher chance of the observer influencing the behavior of a sample group elements. Uncertainties of the event cannot determine the actual time when the event will take place, and this is why every occurrence that is open to observation cannot be observed. Many of the incidents are abstract, like love, affection, and the researcher can't gain an exact and correct account of those. The social phenomena generalization made by observation are not considered reliable as it cannot be used for lab experiments. In some cases, it is seen that two persons observing the same phenomena come at different results, and this can lead to faulty perceptions. Observation method is considered an expensive affair as it requires hard effort, plenty of time and high cost. Question: explain report writing. Report writing in research methodology. A report is a well-written formal document that briefly describes the process and findings of a research. It outlines the systematic investigation, recommendations, and gaps that need further inquiry. A well-crafted research report tells you about all the main areas of a research process. In this article, we will talk about how to write a report in research methodology. Importance of a report in research methodology. Below are some points that make the report crucial in research methodology. 1. Knowledge transfer. A report contributes to the existing knowledge. Through this report, we can communicate effectively with the findings of the investigation. 2. Identification of knowledge gaps. A research report identifies knowledge gaps that can be investigated further. The report shows what and how much has been done. 3. Presents information precisely. A research report makes you able to show research information in a concise and precise manner. 4. Time efficient. A report is a time-efficient document because you don't have to spend much time detailing the findings. Rather, it is written briefly and you can send it through email to the concerned people. Structure of a report in research methodology. You can write the report in the following structure. Title. The title of your research should point to the objectives, aims, and findings of your systematic investigation. Table of contents. The table of contents will make the readers able to navigate your research report. Abstract. In the abstract section, the reader can have an overview of the important aspects of research such as method, data collection, and findings. While writing the abstract, you should follow the format of 5 Ws and 1 H: what, where, when, who, why, and how. Introduction. You can write aims and the problems that become the cause of your research. You should also indicate whether you have achieved your objectives of the research or it requires further work. Literature review. In a literature review, you will write a survey that highlights existing knowledge about the research topic. In the literature review, you can present the research hypothesis and its implications. Investigation. In this portion of the investigation, write in-depth information briefly about the research process that includes methodology, data collection, sample, research subjects, and analysis. Findings. In this portion, you are expected to show the results and findings of your systematic investigation. Discussion. Now, you will further explain the results of the research that you outlined earlier. Justify for each finding and show whether the outcomes are according to the hypothesis or not. Finally, you will write a summary of your research in which you will talk about the whole report of research methodology, reference and appendices. In this section, mention all the primary and secondary sources used during research. Tips for writing a report in research methodology. Before writing a report in research methodology, you must create an outline of its core areas and then write its detail concisely. Below are some tips you can follow while writing a report. 1. Define your audience. Always keep your audience in mind so that you can determine the tone while writing the report. If the report is for a general audience, you can present information in a simple way. While if you are writing for a particular audience, you can use field-specific or technical terms as well. 2. Include significant findings. In report writing, exclude all irrelevant information and only highlight important findings and data. Just present the abridged version of the systematic investigation. 3. Include illustrations. You can use illustrations and visual presentations to make your data more efficient. You can use charts, graphs, and relevant images to bring additional credibility to systematic investigation. 4. Choose the right title. The title of the report should be clear and precise. It must contain keywords of your research. The title should show a clear idea of the investigation so the readers can easily grasp the focus of the research. 5. Proofread the report. After completion of report writing, you must proofread and edit it wherever it needs before you publish the report. The second look will make the information valid and authentic. You can ask someone to go through your report or use any editing and proofreading software as well. 6. Conclusion. A report is a concise document that is the essence of research. So, you should be very careful while writing a report after conducting research. It should be accurate, clear, and concise. Its findings can communicate with the readers. Question: Discuss about the use of historical and comparative research. Historical comparative methodologies. These methods put historical time and cross-cultural variation at the center of the research question, data collection and data analysis. Using these methods requires developing a thorough knowledge of the history and culture surrounding your research question. Use historical comparative methodologies when 1. You want to explore why a particular social outcome occurred. 2. You want to compare a topic across different societies. 3. You want to determine whether an old explanation of a social phenomenon is still valid given what has happened historically since the explanation was developed. Examples of historical comparative research questions. What fundamental features are common to most societies? In the U.S., is race declining in sociological significance compared to social class? What caused revolutionary social change in China? How have Americans' beliefs, values, attitudes and behaviors regarding children changed in the 20th century? How was the institution of medicine changed over the 20th century? Why did capitalism take hold early in the US and not elsewhere? Can draw on both qualitative and quantitative methods, often combining several methodologies. However, usually researchers who use historical comparative methodologies adopt more of a qualitative approach to science and knowledge. Their goal for their research is not to develop the answer, but an answer that is people, place and time specific. Implement surveys, interviews, or other widely used social research methods across several time periods or places. Use research data collected by other social scientists' organizations on multiple countries, such as the Human Relations Area Files, the Ethnographic Atlas, the World Handbook of Political and Social Indicators. Treat as data any records that were created at particular moments in time, for reasons other than research, that shed light on your topic, newspaper articles, letters, advertisements in magazines, the minutes of an organization's meetings, church records on marriages, etc. Treat as data any historical explanations written about the topic, usually by historians. Oral histories of people who lived the topic. Case studies of comparative societies groups. Direct collection of data on the topic being studied is often impossible, because the issue occurred in the past or the people involved are no longer living. Steps in historical comparative research. Goal process. 1. Conceptualize research topic and become familiar with the issues at hand. Setting the history, the culture, etc. 2. Data collection. Locate evidence. Where can you find information on this topic? Library sources, scientific literature, newspapers, museums, organizational records, etc. Evaluate the quality of the above evidence while reviewing the above materials. Answer: A. How relevant is this information to the topic being studied? B. How accurate is the evidence? C. Are there missing pieces of information or people not being represented in this evidence? 3. Analyze data. Organize evidence. Did any patterns appear to you while reviewing the above materials? Are there any similarities or differences in the story told in the above materials? Synthesize. Reread the materials to see if the pattern identified above holds. Are there any exceptions? How so? During this step, develop a more detailed pattern. For dissemination, write report of methods used and findings. Ethical issues in historical comparative research. Overall, there are often fewer ethical issues in historical comparative research than with other methodologies because the data we use in historical comparative research was often collected in the past or is public information. Even with this type of data, though, there are issues to consider. 1. Accuracy of evidence data used. 2. Confidentiality of people who are represented in evidence data. 3. Need to respect cross-cultural variations in customs, values, meanings. 4. Power issues. Often a historical comparative researcher comes from a privileged country to a less privileged country to collect data on the latter. Question: explain the utility of scaling technique in research. Definition: scaling technique is a method of placing respondents in continuation of gradual change in the pre-assigned values, symbols or numbers based on the features of a particular object as per the defined rules. All the scaling techniques are based on 4 pillars, i.e., order, description, distance and origin. The marketing research is highly dependable upon the scaling techniques, without which no market analysis can be performed. Types of scaling techniques. The researchers have identified many scaling techniques. Today, we will discuss some of the most common scales used by business organizations, researchers, economists, experts, etc. These techniques can be classified as primary scaling techniques and other scaling techniques. Let us now study each of these methods in depth below. Primary scaling techniques. The major 4 scales used in statistics for market research consist of the following. Nominal scale. Nominal scales are adopted for non-quantitative, containing no numerical implication, labeling variables which are unique and different from one another. Types of nominal scales. 1. Dichotomous. A nominal scale that has only 2 labels is called dichotomous, for example, yes, no. 2. Nominal with order. The labels on a nominal scale arranged in an ascending or descending order is termed as nominal with order, for example, excellent, good, average, poor, worst. 3. Nominal without order. Such nominal scale which has no sequence is called nominal without order, for example, black, white. Ordinal scale. The ordinal scale functions on the concept of the relative position of the objects or labels based on the individual's choice or preference. For example, at Amazon.in, every product has a customer review section where the buyers rate the listed product according to their buying experience, product features, quality, usage, etc. The ratings so provided are as follows: 5-star excellent, 4-star good, 3-star average, 2-star poor, 1-star worst. Interval scale. An interval scale is also called a cardinal scale, which is the numerical labeling with the same difference among the consecutive measurement units. With the help of this scaling technique, researchers can obtain a better comparison between the objects. For example, a survey conducted by an automobile company to know the number of vehicles owned by the people living in a particular area who can be its prospective customers in future. It adopted the interval scaling technique for the purpose and provided the units as 1, 2, 3, 4, 5, 6 to select from. In the scale mentioned above, every unit has the same difference, i.e., 1, whether it is between 2 and 3 or between 4 and 5. Ratio scale. One of the most superior measurement technique is the ratio scale. Similar to an interval scale, a ratio scale is an abstract number system. It allows measurement at proper intervals, order, categorization and distance, with an added property of originating from a fixed 0 point. Here, the comparison can be made in terms of the acquired ratio. For example, a health product manufacturing company surveyed to identify the level of obesity in a particular locality. It released the following survey questionnaire: select a category to which your weight belongs to. Less than 40 kilograms, 40 to 59 kilograms, 60 to 79 kilograms, 80 to 99 kilograms, 100 to 119 kilograms, 120 kilograms and more. Other scaling techniques. Scaling of objects can be used for a comparative study between more than one objects, products, services, brands, events, etc. Or can be individually carried out to understand the consumer's behavior and response towards a particular object. Following are the two categories under which other scaling techniques are placed based on their comparability. Comparative scales. For comparing two or more variables, a comparative scale is used by the respondents. Following are the different types of comparative scaling techniques. Paired comparison. A paired comparison symbolizes two variables from which the respondent needs to select one. This technique is mainly used at the time of product testing, to facilitate the consumers with a comparative analysis of the two major products in the market. To compare more than two objects, say comparing P, Q and R, one can first compare P with Q and then the superior one, i.e., one with a higher percentage, with R. For example, a market survey was conducted to find out consumers' preference for the network service provider brands, A and B. The outcome of the survey was as follows. Brand A is equal to 57%. Brand B is equal to 43%. Thus, it is visible that the consumers prefer brand A over brand B. Rank order. In rank order scaling, the respondent needs to rank or arrange the given objects according to his or her preference. For example, a soap manufacturing company conducted a rank order scaling to find out the orderly preference of the consumers. It asked the respondents to rank the following brands in the sequence of their choice. Soap brands rank: brand V4, brand X2, brand Y1, brand Z3. The above scaling shows that soap, Y, is the most preferred brand, followed by soap, X, then soap, Z, and the least preferred one is the soap, V. Constant sum. It is a scaling technique where a continual sum of units like dollars, points, chits, chips, etc. is given to the features, attributes and importance of a particular product or service by the respondents. For example, the respondents belonging to 3 different segments were asked to allocate 50 points to the following attributes of a cosmetic product. P. Q-sort scaling. Q-sort scaling is a technique used for sorting the most appropriate objects out of a large number of given variables. It emphasizes on the ranking of the given objects in a descending order to form similar piles based on specific attributes. It is suitable in the case where the number of objects is not less than 60 and more than 140, the most appropriate of all ranging between 60 to 90. For example, the marketing manager of a garment manufacturing company sorts the most efficient marketing executives based on their past performance, sales revenue generation, dedication and growth. The Q-sort scaling was performed on 60 executives, and the marketing head creates 3 piles based on their efficiency as follows. In the above diagram, the initials of the employees are used to denote their names. Non-comparative scales. A non-comparative scale is used to analyze the performance of an individual product or object on different parameters. Following are some of its most common types. Continuous rating scales. It is a graphical rating scale where the respondents are free to place the object at a position of their choice. It is done by selecting and marking a point along the vertical or horizontal line which ranges between two extreme criteria. For example, a mattress manufacturing company used a continuous rating scale to find out the level of customer satisfaction for its new comfy bedding. The response can be taken in the following different ways, stated as versions here. The above diagram shows a non-comparative analysis of one particular product, i.e. comfy bedding. Thus, making it very clear that the customers are quite satisfied with the product and its features. Itemized rating scale. Itemized scale is another essential technique under the non-comparative scales. It emphasizes on choosing a particular category among the various given categories by the respondents. Each class is briefly defined by the researchers to facilitate such selection. The three most commonly used itemized rating scales are as follows. Likert scale. In the Likert scale, the researcher provides some statements and asks the respondents to mark their level of agreement or disagreement over these statements by selecting any one of the options from the 5 given alternatives. For example, a shoes manufacturing company adopted the Likert scale technique for its new sports shoe range named Z Sports Shoes. The purpose is to know the agreement or disagreement of the respondents. For this, the researcher asked the respondents to circle a number representing the most suitable answer according to them, in the following representation. 1. Strongly disagree. 2. Disagree. 3. Neither agree nor disagree. 4. Agree. 5. Strongly agree. The above illustration will help the company to understand what the customers think about its products. Also, whether there is any need for improvement or not. Semantic differential scale. A bipolar 7-point non-comparative rating scale is where the respondent can mark on any of the 7 points for each given attribute of the object as per personal choice, thus, depicting the respondent's attitude or perception towards the object. For example, a well-known brand for watches carried out semantic differential scaling to understand the customer's attitude towards its product. The pictorial representation of this technique is as follows. From the above diagram, we can analyze that the customer finds the product of superior quality. However, the brand needs to focus more on the styling of its watches. Stapel scale. A Stapel scale is that itemized rating scale which measures the response, perception or attitude of the respondents for a particular object through a unipolar rating. The range of a Stapel scale is between 5 to plus 5 eliminating 0, thus confining to 10 units. For example, a tours and travel company asked the respondent to rank their holiday package in terms of value for money and user-friendly interface as follows. With the help of the above scale, we can say that the company needs to improve its package in terms of value for money. However, the decisive point is that the interface is quite user-friendly for the customers. Scaling techniques provide a clear picture of the product life cycle and the market acceptability of the products offered. It facilitates product development and benchmarking through rigorous market research. Question: Object of legal research. Knowing where to start a difficult legal research project can be a challenge. But if you already understand the basics of legal research, the process can be significantly easier, not to mention quicker. So, Whether you are a student still in law school or a seasoned attorney with years of experience, having solid research skills is crucial to be able to craft a winning argument. This is why it is so important to know how to perform legal research, including where to start and the steps to follow. Step 1. What is legal research, and where do I start? Black's Law Dictionary defines legal research as he finding and assembling of authorities that bear on a question of law. But what does that actually mean? Essentially, it means that legal research is the process you use to identify and find the laws, including statutes, regulations, and court opinions, that apply to the facts of your case. In most instances, the purpose of legal research is to find support for a specific legal issue or decision. For example, attorneys must conduct legal research if they need court opinions, that is, case law, to back up a legal argument they are making in a motion or brief filed with the court. Alternatively, lawyers may need legal research to simply provide clients with accurate legal guidance. And in the case of law students, they often use legal research to complete memos and briefs for class. But these are just a few of the situations in which legal research is necessary. Key questions to ask yourself when starting legal research. Before you start looking for laws and court opinions, you first need to define the scope of your legal research project. There are several key questions you can use to help do this. What are the facts? Always gather the key facts so you know the who, what, why, when, where, and how of your case. And take the time to write everything down, especially since you will likely need to include a statement of facts in an eventual filing or brief anyway. Even if you don't think a fact may be relevant now, write it down because it may turn out to be relevant later. These facts will also be helpful when identifying your legal issue. What is the actual legal issue? You will never know what to actually research if you don't know what your legal issue is. Does your client need help collecting money from an insurance company following a car accident involving a negligent driver? How about a criminal case involving the exclusion of evidence found during an alleged illegal stop? No matter the legal research project, you must identify the relevant legal problem as well as the outcome or relief sought. This information will guide your research so you can stay focused and on topic. What is the relevant jurisdiction? Don't cast your net too wide when it comes to legal research, meaning, you should focus on the relevant jurisdiction. For example, does your case deal with federal or state law? And if it is state law, which state? You may find a case in California State Court that is exactly on point, but it won't be very helpful if your legal project involves New York law. Where to start legal research, the library or online? In years past, future attorneys were trained in law school to do their research in the library. But now, pretty much everything from the library, and more, can be found online. And while you can certainly still use the library if you want, you will probably be costing yourself valuable time if you do. When it comes to online research, some people start with free legal research options, including search engines like Google or Bing. But if you want to make sure your legal research is comprehensive, you will want to use an online research service designed specifically for the law, such as Westlaw. Not only do online solutions like Westlaw have all the legal sources you need, but they also include artificial intelligence, AI, and other tools that can help make quick work of your legal research. Step 2. How to find relevant case law and other primary sources of law. Now that you have gathered the facts and know your legal issue, the next step is knowing what to look for. After all, you will need law to support your legal argument, whether you are providing guidance to a client or writing an internal memo, brief, or some other legal document. But what type of law do you need? The answer: primary sources of law. Some of the more important types of primary law include case law, which are court opinions, decisions issued by federal or state courts. Statutes, including legislation passed by both the U.S. Congress and state lawmakers. Regulations, including those issued by either federal or state agencies. Constitutions, both federal and state. Searching for primary sources of law. So, if it's primary law you want, it makes sense to begin searching there first, right? Not so fast. While you will need primary sources of law to support your case, in many instances, it is much easier, and a more efficient use of your time, to begin your search within secondary sources such as practice guides, treatises, and legal articles. Why? Because secondary sources provide you with a thorough overview of legal topics, meaning you don't have to start your research from scratch. After secondary sources, you can move on to primary sources of law. For example, while no two legal research projects are the same, the order in which you will want to search different types of sources may look something like this. Secondary sources. If you are researching a new legal principle or an unfamiliar area of the law, the best place to start is secondary sources, including law journals, practice guides, legal encyclopedias, and treatises. They are a good jumping-off point for legal research since they have already done the work for you. And as an added bonus, they can save you additional time since they often identify and cite important statutes and seminal cases. Case law. If you have already found some case law in secondary sources, great, you have something to work with. But if not, don't fret, you can still search for relevant case law in a variety of ways, including running a search in an online legal research service like Westlaw. And once you find a helpful case, you can use it to find others. For example, in Westlaw, most cases contain headnotes that summarize each of the case's important legal issues. These headnotes are also assigned a key number based on the topic associated with that legal issue. So, once you find a good case, you can use the headnotes and key numbers within it to quickly find more relevant case law. Statutes and regulations. In many instances, secondary sources and case law will list the statutes and regs relevant to your legal issue. But if you haven't found anything yet, you can still search for statutes and regs online like you do with cases. Once you know which statute or reg is pertinent to your case, pull up the annotated version on Westlaw. Why the annotated version? Because the annotations will include vital information such as a list of important cases that cite your statute or reg. And sometimes, these cases are even organized by topic. This is just one more way to find the case law you need to support your legal argument. Keep in mind, though, legal research isn't always a linear process. You may start out going from source to source as outlined above, and then find yourself needing to go back to secondary sources once you have a better grasp of the legal issue. In other instances, you may even find the answer you are looking for in a source not listed above, like a sample brief that was filed with the court by another attorney. Ultimately, you need to go where the information takes you. Step 3. Make sure you are using good law. One of the most important steps with every legal research project is to verify that you are using good law, meaning a court hasn't invalidated it or struck it down in some way. After all, it probably won't look good to a judge if you cite a case that has been overruled or you use a statute that has been deemed unconstitutional. It doesn't necessarily mean you can never cite these sources, you just need to take a closer look before you do. The simplest way to find out if something is still good law is to use a legal tool known as a citator, which will show you subsequent cases that have cited your source as well as any negative history, including if it has been overruled, reversed, questioned, or merely differentiated. For instance, if a case, statute, or regulation has any negative history, and therefore may no longer be good law, KeyCite, which is the citator on Westlaw, will warn you. Specifically, KeyCite will show a flag or icon at the top of the document along with a little blurb about the negative history. This allows you to quickly know if there may be anything you need to worry about. Some examples of these flags and icons include: a red flag on a case warns you it is no longer good for at least one point of law, meaning it may have been overruled or reversed on appeal. A yellow flag on a case warns that it has some negative history but not expressly overruled or reversed, meaning another court may have criticized it or pointed out the holding was limited to a specific fact pattern. A blue striped flag on a case warns you that it has been appealed to the U.S. Supreme Court or the U.S. Court of Appeals. The KeyCite overruling risk icon on a case warns you that the case may be implicitly undermined because it relies on another case that has been overruled. Another bonus of using a citator like KeyCite is that it also provides a list of other cases that merely cite your source. It can lead to additional sources you previously didn't know about. Question: legal education and legal aid. The majority of the population is illiterate in India, which is the second most populous nation on earth. The concept of seeking justice cannot be linked with the value of dollars, Justice Harry Blackmun stated. Justice cannot be obtained through the use of money, which is the second most populous nation on earth. The concept of seeking justice cannot be linked with the value of dollars, Justice Harry Blackmun stated. Justice cannot be obtained through the use of money. The majority of people are ignorant of their protected rights as well as the nation's legal system. What is the meaning of legal aid? Legal aid is help given to those who, without it, would not be able to afford legal counsel or access the justice system. Legal assistance actually makes sure you have a competent attorney when you exercise your right to a fair trial in order to give you access to justice. Legal assistance is crucial in ensuring that everyone has access to justice on an equal basis. There are several ways to provide legal aid, including duty attorneys, community legal centers, and paying attorneys to handle cases for people who qualify for legal aid. What is legal aid in India? Legal aid refers to uncompensated legal services that advance societal benefit. Numerous initiatives in this regard have been made in India, such as the implementation of Lok Adalats. A defendant has the right to request legal help if he cannot pay it, as stated in a number of Indian constitutional articles. According to Article 14 of the Indian Constitution, the state shall not deny to any individual within the territory of India equality before the law or the equal protection of the laws. The Indian legislature kept in mind the fear of extreme inequality caused by the parties' disparities in wealth when drafting the phrase, equal protection of the laws. The Indian Constitution's preamble aspires to guarantee socio-economic and political justice to the Indian people. The Indian Constitution's Articles 38 and 39 are notable. According to Article 38, 1, of the Constitution, the state must safeguard and protect the social order, including justice, and according to Article 39- of the Constitution, mandates that it must specifically provide free legal aid through appropriate legislation or programs to ensure that no citizen is denied the opportunity to pursue justice. A just society must ensure that there is a strong, publicly funded legal aid system to address these demands. Society must make sure that there is a system of legal assistance available to help individuals who otherwise cannot afford legal counsel or representation when they need it. History of legal aid in India. Legal assistance and the welfare state are closely related, and a state's decision to offer legal help is determined by its welfare policies. Legal aid is a welfare benefit offered by the government to those who would otherwise be unable to afford legal representation. By giving those who are entitled to welfare benefits, such as social housing, access to legal counsel and the courts, legal aid also contributes to ensuring that welfare provisions are upheld. Legal aid has historically been important in ensuring the respect for economic, social, and cultural rights that are involved with social security, housing, social care, health care, and education service provision, which may be provided publicly or privately, as well as employment law and anti-discrimination legislation. Legal experts like Moro Capelletti contends that access to justice is facilitated by legal aid since it enables people to assert their economic, social, and cultural rights on a personal level. His beliefs came into being in the latter half of the 20th century, when democracies with capitalist economies created liberal welfare states that prioritized the individual. Before the middle of the 20th century, the emphasis in legal assistance literature was on collectively enforcing economic, social, and cultural rights. A fundamental tenet of the development of traditional welfare states in the decades after World War II was that economic, social, and cultural rights were the duty of all people, and that the state would take care of those who couldn't care for themselves due to disease or unemployment. Who is entitled to get legal aid? The following social groups have the right to free legal assistance under Section 12 of the Legal Services Authorities Act. A person who belongs to a scheduled caste or tribe. A beggar or victim of human trafficking as defined in Article 23 of the Constitution. A girl or a kid. A person who is mentally sick or otherwise impaired. A person experiencing unjustified want due to, for example, being a victim of an industrial tragedy, a mass disaster, ethnic conflict, caste cruelty, flood, drought, or other calamity, or a worker in industry, or in custody, including custody in a protective home as defined by Section 2 of the Immoral Traffic Prevention Act, 1956, 104 of 1956, or in a juvenile home as defined by Section 2 of the Juvenile Justice Act, 1986, 53 of 1986, or in a psychiatric hospital or psychiatric nursing home as defined by Section 2 of the Mental Health Act, 1987, 14 of 1987, or when the matter is before a court other than the Supreme Court, and when the yearly income is less than 9,000 rupees or another higher sum defined by the state government, and when the annual income is less than 12,000 rupees or another higher amount prescribed by the central government, if the case is before the Supreme Court and High Court. Legal assistance for the poor is essential for the preservation of legal principles, which is necessary for the existence of an ordered society. It implies providing free legal services to the impoverished and underprivileged who cannot afford to pay for a legal representative's services during the course of a case in a court, counsel, or before an expert. Distributive justice, the efficient administration of welfare payments, and the eradication of social and fundamental injustices against the poor are the main focuses of legal aid. It operates in accordance with the Legal Services Authorities Act of 1987, which serves as the framework for the provision of free equity. Legal education institutions. The Law Commission of India defines legal education as a science which imparts to students knowledge of certain principles and provisions of law to enable them to enter the legal profession. Law, legal education and development have become interrelated concepts in modern developing countries. The main function of the legal education is to produce lawyers with social vision. However, in modern times legal education should not only produce lawyers, it should be regarded as a legal instrument for social design. According to Justice Krishna Iyer, profession of law is a noble calling and the members of the legal profession occupy a very high status. Law is the foundation of every society and it develops abiding citizens, lawyers, academicians and aspiring judges. Legal education in India refers to education of lawyers before their entry into practice. Historically speaking, legal education traces back to ancient period, where the kings and princes were given teachings about dharma and nyaya. Then the concept of legal representatives came into existence during Mughal period. Legal education was in existence even before Indian independence as many of our freedom fighters are from legal background. But, it gained its significance only in post-independence period. Law courses are offered for a term of 3 years in some traditional universities but it can be pursued only after getting a degree. Later, introduction of 5 years law courses and establishment of National Law University at Bangalore have made legal education quite popular in 21st century. At present, there were about 21 national law universities in India and about 1,200 law colleges including public and private universities. This article deals with the role of Bar Council of India regulating the legal education in India. Aims of legal education. Legal education should not only produce lawyers but should be regarded as a legal instrument for social design. The main aims of legal education are as follows. To train students for legal profession. To educate the students to solve the individual client's problems as well as to solve the society's problems in which he lives. To provide a center where scholars might contribute to understanding of law and participate in their growth and improvement. To inculcate students with operative legal rules and to provide them adequate experience to apply these rules. To point the right road for future development. Thus, legal education should aim at furnishing skills and competence for creation and maintenance of just society. Objectives of legal education. The objectives of legal education may be multifold in a developing democratic country like India. They are to develop perceptions and to understand the problems of one's society and to influence values and attitudes. To generate different kinds of skills and knowledge needed for tasks in society. To broaden opportunity and mobility in society, notably among groups who may have been deprived. to develop research of value to education and society with use of educational facilities. Importance of legal education. Legal education is a broad concept. It includes the profession which is practiced in court of law, law teaching, law research and administration in different branches where law plays a pivotal role. It injects a sense of equality before law. The standard of bar and bench is the reflection of the quality and standard of the legal education acquired at the law school. Knowledge of law increases if one understands the affairs of the state. The importance of legal education cannot be overemphasized in a democratic society. It is necessary duty of everyone to know the law. Ignorance of law cannot be excused. Thus, legal education not only produces efficient lawyers but also creates law-abiding citizens with human values and rights. Factors that influence legal education in India. Legal education is influenced by a multitude of factors. They are as follows. Governmental policy. Bar Council of India. University Grants Commission. Affiliating universities. Private governing body of law colleges. National litigation policy. Developments in legal profession. Developments in the legal system. The kind of students who enroll. The caliber and commitment of the faculty. The infrastructure available. Technological advancements. The developments in other fields of education. The changes in the society. Private universities have played a significant role in exploring the changes in legal education over the last decade. They engage in field of legal education and strive to improve the quality of legal education in India. On the other hand, national law schools laid emphasis on specialized learning. Many institutions have conferred altogether with the lecture method of teaching and have instead opted more interactive and innovative methods of learning. Law schools in India have a proliferating culture of moot courts which has made legal education far more practical and behavioral than simply learning the letter of law. The significance on co-curricular activities like seminars, workshops etc. have now become indivisible part of the course. Internships during the period of study are now a mandatory requirement. On-campus recruitments become a common feature of most of law schools. Question: discuss the concept of women empowerment. The main objective behind this article is neither to favor the prevalence of feminism nor to be criticizing about the chauvinism. The focal point of this article is to promote equality. In today's scenario, the empowerment of women has become one of the most important concerns of 21st century. But practically women empowerment is still an illusion of reality. We observe in our day-to-day life how women become victimized by various social evils. Women empowerment is the vital instrument to expand women's ability to have resources and to make strategic life choices. Empowerment of women is essentially the process of upliftment of economic, social and political status of women, the traditionally underprivileged ones, in the society. It is the process of guarding them against all forms of violence. Women empowerment is giving legitimate power or authority to perform the tasks. People of India used to say this country as Bharat Mata, however never realized the true meaning of it. Bharat Mata means a mother of every Indian whom we have to save and respect. Women population is around 50% of the total population of the world. Reflecting into the Vedas Purana of Indian culture, women is being worshipped such as Lakshmi Ma, goddess of wealth, Saraswati Ma, for wisdom, Durga Ma for power. Nowadays, women are increasingly gaining control over their lives and are actively taking their own decisions with regard to their education, career, profession and lifestyle. Women have demanded equality with men in matters of education, employment, inheritance, marriage, and politics, and recently in the field of religion also to serve as priest. Also, women need to be given equal opportunities for education and employment without any sense of discrimination. What is women empowerment? Women empowerment implies the ability in women to take decisions with regard to their life and work and giving equal rights to them in all spheres like personal, social, economic, political, legal, and so on. We are living in an age of women empowerment where women are working shoulder to shoulder with men. A woman also manages to balance between their commitment to their profession as well as their home and family. They are playing multiple roles, at home as a mother, daughter, sister, and wife, and at working place as professionals with remarkable simplicity and compatibility. Women empowerment is essential for the betterment of any country's future as they play dual responsibilities of managing their families while simultaneously juggling to earn to contribute in fulfilling their family needs. No one can ever ignore the importance of the role of a mother, sister, or a daughter in their families. At the same time, women have also established themselves as equal contributors in managing the financial requirements of their homes. On international level as well, women have successfully created their unbeatable position, but they are just a handful in comparison to their counterparts. Women empowerment is not limited to urban, and even women in remote towns and villages are now increasingly making their voices heard loud and clear in society. While it is true that women, to a large extent, do not face discrimination in society today, unfortunately, many of them face exploitation and harassment which can be of diverse types: emotional, physical, mental, and sexual. They are often subjected to rape, abuse, and other forms of physical and intellectual violence. Women are now claiming the socio-political rights, right to work, right to education, right to decide, etc., for them. The Parliament of India too has passed various legislations to save women from various forms of injustice and discrimination. To empower women there are some following laws: Equal Remuneration Act 1976, Dowry Prohibition Act 1961, Immoral Traffic Prevention Act 1956, Medical Termination of Pregnancy Act 1971, Maternity Benefit Act 1961, Commission of Sati Prevention Act 1987, Prohibition of Child Marriage Act 2006, Preconception and Prenatal Diagnostic Techniques, Regulation and Prevention of Misuse, Act 1994, and Sexual Harassment of Women at Workplace, Prevention, Protection and Act 2013. More recently, in the wake of Nirbhaya case involving the rape and brutal murder of paramedical student in Delhi, the government has passed the Juvenile Justice, Care and Protection of Children Bill, 2015. This act makes a significant departure from the earlier Juvenile Justice, Care and Protection of Children Act, 2000, as the juvenile age inviting punishment for offense now stands reduced from 18 to 16 years. The most famous pearl of wisdom said by the Pandit Jawaharlal Nehru is to awaken the people. It is the women who must be awakened. Once she is on the move, the family moves, the village moves, the nation moves. In India, to empower the women, first it needs to kill all the demons killing women's rights and values in the society, such as dowry system, illiteracy, sexual harassment, inequality, female infanticide and domestic violence against women, rape, prostitution, illegal trafficking and other issues. Gender discrimination in the nation brings cultural, social, economic and educational differences which push country back. The most effective remedy to kill such devils is making women empowered by ensuring the right to equality mentioned in the Article 14, Constitution of India. According to the provisions of the Constitution of India, it is a legal point to grant equality to women in the society in all spheres just like males have. The women are given a top place in India from the ancient time, however they were not given empowerment to participate in all areas. They need to be strong, aware and alert every moment for their growth and development. Empowering women is the main motto of the development department because an empowered mother with child makes the bright future of any nation. Position and status of women. The position and status of women all over the world has risen extraordinarily in the 20th century. We find that it has been very low in past centuries in India and hence they were treated like objects that can be bought and sold. For a long time women in India remained within the four walls of their household. They totally depend on menfolk. In India, the customs of Parda, well system, female infanticide, child marriage, sati system, self-immolation by the women with their husbands, dowry system and the state of permanent widowhood were totally removed. It would help the innumerable women in the country who get neglected by their husbands and have no means of proving their marital status. It would also help check child marriages, bigamy and polygamy, enable women to seek maintenance and custody of their children and widows can claim inheritance rights. The Act is applicable on all women irrespective of caste, creed or religion. It truly helps to empower Indian women to exercise their rights. Benefits of women empowerment. Women empowerment raises confidence of women in their ability to lead meaningful and purposeful lives. It eliminates their dependence on others and makes them individuals in their own right. They are able to lead their lives with dignity and freedom which increase their self-esteem and give them a unique identity. They are able to gain recognition and form a meaningful contribution to the well-being of society. Women act as capable citizens to make the country achieve and boost gross domestic product (GDP) growth. As they are financially independent, they are able to spend on all their needs and desires, and they also get fair and equitable access to resources of the country. Necessity of women's empowerment. Without women's empowerment, we cannot remove injustice and gender bias and inequalities. If women are not empowered, they are deprived from enjoying security and protection in life. It also provides them a secure working environment. Empowerment acts as a powerful tool against exploitation and harassment of women. It is a great means to get adequate legal protection for women. If not socially and economically empowered, women cannot blossom their own identity in society, and if they are not employed, the global economy will be adversely affected as women constitute a large extent of the world's population. As women are highly creative and intelligent, this makes it mandatory to receive their contributions in socio-economic activities. For a just and progressive society, women need to be provided equal opportunities for work. The challenges barriers of women empowerment are the following. Because of the inherent dominance among the males, they often don't allow their female counterpart to rise as high as them. Women are bound to high level of domestic responsibilities, and they are also restricted to participate in social, economic and religious activities. In our society, preference for male child still exists and priority for education and healthy diet given to the boy child over girl child. To overcome barriers, education through mass communication is very important. Both women and men should have aware of their responsibilities for promoting and practicing gender equality. Accumulate national data and identify the areas where occurrence of violence and gender inequality is on peak. This data can be used by the government, NGOs and field workers to increase the status of women. The society should be made aware that both boy child and girl child are equally treated, and they both should have equal access to available resources. A person may be said as powerful, when he/she may have the right of particular things and also have control on a large particular portion of power resources such as knowledge, education, social status, capabilities of mobilization, personal wealth, leadership training, etc. Summit on Women Empowerment. The summit called Women Up, organized by SIAHI, a literary agency, commences in October 2019. Financial independence for women is not just about being a part of the workforce. For women to be truly financially independent, it is extremely imperative for men to be active allies and equitable partners in taking up the responsibility of domestic and familiar affairs. The Women Up Summit will reflect on such crucial yet often overlooked subjects in the advancement of gender equality. Another theme that will be dwelt upon is the need for science and entrepreneurship to work together as engines of societal change. With several sessions in Hindi, the bilingual nature of the summit makes it an inclusive platform for people from all walks of life to learn and be inspired. Mita Kapoor, founder, curator and producer of Women Up Summit said. Leading cases. In case of C.B. Muthumma v. Union of India, 1979, 4 SCC 260, 44, a writ petition was filed by Ms. Muthumma, a senior member of the Indian Foreign Service, complaining that she had been denied promotion to grade I illegally and unconstitutionally. She pointed out that several rules of the civil service were discriminatory against women. At the very threshold, she was advised by the chairman of the UPSC against joining the Foreign Service. At the time of joining, she was required to give an undertaking that if she married, she would resign from service. Under Rule 18 of the Indian Foreign Service, Recruitment, Cadre, Seniority and Promotion, Rules, 1961, it was provided that no married woman shall be entitled as of right to be appointed to the service. Under Rule 8, 2, of the Indian Foreign Service, Conduct and Discipline, Rules, 1961, a woman member of the service was required to obtain permission of the government in writing before her marriage was solemnized. At any time after the marriage, she could be required to resign if the government was confirmed that her family and domestic commitments were likely to come in the way of the due and efficient discharge of her duties as a member of the service. On numerous occasions, the petitioner had to face the consequences of being a woman and thus suffered discrimination. Though the Constitution specifically under Article 15 prohibits discrimination on grounds of religion, race, caste, sex or place of birth, and Article 14 provides the principle of equality before law. In case of Air India v. Narjesh Mirza, 1981, 4 SCC 335, 45, Narjesh Mirza filed a writ petition. In this case, the air hostesses of the Air India International Corporation had approached the Supreme Court against, again, discriminatory service conditions in the regulations of Air India. The regulations provided that an air hostess could not get married before completing 4 years of service. Usually an air hostess was recruited at the age of 19 years, and the 4-year bar against marriage meant that an air hostess could not get married until she reached the age of 23 years. If she married earlier, she had to resign, and if after 23 years she got married, she could continue as a married woman but had to resign on becoming pregnant. If an air hostess survived both these filters, she continued to serve until she reached the age of 35 years. It was alleged on behalf of the air hostesses that those provisions were discriminatory on the ground of sex, as similar provisions did not apply to male employees doing similar work. The Supreme Court upheld the first requirement that an air hostess should not marry before the completion of 4 years of service. The court held that it was a sound and salutary provision. Apart from improving the health of the employee, it helps a great deal in the promotion and boosting up of our family planning program. However, this argument given by the court came in for criticism that as the requirements of age and family planning were warranted by the population policy of the state, and once the state had fixed the age of marriage, i.e. 18 years, the reasoning advanced for upholding the rule was a camouflage for the real concern. The Supreme Court struck down the Air India regulations relating to retirement and the pregnancy bar on the services of air hostesses as unconstitutional on the ground that the conditions laid down therein were entirely unreasonable and arbitrary. The impugned Regulation 46 provided that an air hostess would retire from the service of the corporation upon attaining the age of 35 years or on marriage, if it took place within 4 years of service, or on first pregnancy, whichever occurred earlier. Under Regulation 7, the managing director was vested with absolute discretion to extend the age of retirement prescribed at 45 years. Both these regulations were struck down as violative of Article 14, which prohibits unreasonableness and arbitrariness. Legal and constitutional provisions for women in India. The principle of gender equality is enshrined in the Indian Constitution in its preamble, fundamental rights, fundamental duties and directive principles. The Constitution not only grants equality to women, but also empowers the state to adopt measures of positive discrimination in favor of women. Within the framework of a democratic polity, our laws, development policies, plans and programs have aimed at women's advancement in different spheres. Gender equality includes protection from sexual harassment and right to work with dignity, which is a universally recognized basic human right. Legal provisions. To uphold the constitutional mandate, the state has enacted various legislative measures intended to ensure equal rights, to counter social discrimination and various forms of violence and atrocities, and to provide support services especially to working women. Although women may be victims of any of the crimes such as murder, robbery, cheating, etc., the crimes, which are directed specifically against women, are characterized as crime against women. These are broadly classified under 2 categories. 1. The crimes identified under the Indian Penal Code, IPC. Rape, Sec 376 IPC. Kidnapping and abduction for different purposes, Sec 363 to 373. Homicide for dowry, dowry deaths or their attempts, Sec 302/304B IPC. Torture, both mental and physical, Sec 498-A IPC. Molestation, Sec 354 IPC. Sexual harassment, Sec 509 IPC. Importation of girls, up to 21 years of age. 2. The crimes identified under the Special Laws, SLL. Although all laws are not gender-specific, the provisions of law affecting women significantly have been reviewed periodically and amendments carried out to keep pace with the emerging requirements. Some acts which have special provisions to safeguard women and their interests are the Special Marriage Act, 1954. The Hindu Marriage Act, 1955. The Maternity Benefit Act, 1961, amended in 1995. Dowry Prohibition Act, 1961. The Medical Termination of Pregnancy Act, 1971. The Equal Remuneration Act, 1976. The Prohibition of Child Marriage Act, 2006. The Criminal Law Amendment Act, 1983. Indecent Representation of Women Prohibition Act, 1986. Commission of Sati Prevention Act, 1987. The Protection of Women from Domestic Violence Act, 2005. B. Constitutional Provisions. The Constitution of India not only grants equality to women but also empowers the state to adopt measures of positive discrimination in favor of women for neutralizing the cumulative socio-economic, education and political disadvantages faced by them. Fundamental rights, among others, ensure equality before the law and equal protection of law, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth, and guarantee equality of opportunity to all citizens in matters relating to employment. Articles 14, 15, 15, 3, 16, 39, A, 39, B, 39, C, and 42 of the Constitution are of special importance in this regard. Constitutional Privileges. Article 14, Equality before law for women. According to Article 14, the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. Article 15, Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth. Article 15, 1. The state shall not discrimination against any citizen on grounds only of religion, race, caste, sex, or place of birth or any of them. Article 15, 3. The state to make any special provision in favor of women and children. Article 16, Equality of opportunity in matters of public employment. Article 16, 1. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. Article 19, Freedom of speech and expression. Article 19, 1, a, states that all citizens shall have the right to freedom of speech and expression. Article 21, Protection of life and personal liberty. No person shall be deprived of his life or personal liberty except according to procedure established by law. Article 39, Directive Principles of State Policy. Article 39, a, the state to direct its policy towards securing for men and women equally the right to an adequate means of livelihood. Article 39, d, directs the state to secure equal pay for equal work for both men and women. Article 39a, to promote justice on a basis of equal opportunity and to provide free legal aid by suitable legislation or scheme or in any other way to ensure that opportunities for securing justice are not denied to any citizen by reason of economic or other disabilities. Article 42 of the Constitution incorporates a very important provision for the benefit of women. It directs the state to make provision for securing just and humane conditions of work and for maternity relief. Article 51, i.e., is related to women. It states that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religion, linguistic, regional or sectional diversities, to renounce practices derogatory to the dignity of women. Article 243d, Reservation of seats. Article 243d, 1. Seats shall be reserved for a. The scheduled castes, and b. the scheduled tribes. Article 243d, 2. Not less than one-third of the total number of seats reserved under Clause 1 shall be reserved for women belonging to the scheduled castes or, as the case may be, the scheduled tribes. Article 243d, 3. Not less than one-third, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every panchayat to be reserved for women, and such seats to be allotted by rotation to different constituencies in a panchayat. Article 243d, 4. Not less than one-third of the total number of offices of chairpersons in the panchayat at each level to be reserved for women. Article 243t, Reservation of seats. Article 243t, 3. Not less than one-third, including the number of seats reserved for women belonging to the scheduled castes and the scheduled tribes, of the total number of seats to be filled by direct election in every municipality to be reserved for women, and such seats to be allotted by rotation to different constituencies in a municipality. Article 243t, 4. Reservation of offices of chairpersons in municipalities for the scheduled castes, the scheduled tribes and women in such manner as the legislature of a state may by law provide. See Special Initiatives for Women. 1. National Commission for Women. In January 1992, the government set up this statutory body with a specific mandate to study and monitor all matters relating to the constitutional and legal safeguards provided for women, review the existing legislation to suggest amendments wherever necessary, etc. 2. Reservation for women in local self-government. The 73rd Constitutional Amendment Acts passed in 1992 by Parliament ensure one-third of the total seats for women in all elected offices in local bodies, whether in rural areas or urban areas. 3. The National Plan of Action for the Girl Child, 1991 to 2000. The plan of action is to ensure survival, protection and development of the girl child with the ultimate objective of building up a better future for the girl child. 4. National Policy for the Empowerment of Women, 2001. The Department of Women and Child Development in the Ministry of Human Resource Development has prepared a national policy for the empowerment of women in the year 2001. The goal of this policy is to bring about the advancement, development and empowerment of women in socio-economic and politico-cultural aspects, by creating in them awareness on various issues in relation to their empowerment. Government enactments. The National Commission for Women has in the last few years introduced several new bills in the Parliament from time to time towards eradication of many social evils. Some of the significant enactments are mentioned here. Beti Padhao Beti Bachao Yojana. The Dowry Prohibition Act, 1961. The Hindu Widow Remarriage Act of 1856. In the traditions at Hindu society there was a ban on widow remarriage. It was one of the most important evils from which women in the traditional Hindu society suffered a lot. This act allowed widow to remarry, and Section 5 of this act ensured her to enjoy all the rights which a married woman did. The Child Marriage Restraint Act of 1929. The practice of child marriage was another social evil from which women in traditional Hindu society suffered a lot. Age at marriage for girls was 9 or 10, and after passing this act the minimum marriageable age of women was fixed to 15 years. Later this age was increased up to 18 years. The Hindu Marriage Act of 1955. This act has recognized the equal rights of men and women in the matters of marriage and divorce. Under the provision of this act, either the man or woman, too, can present a petition in a court of law for divorce. Wife has got equal right to divorce husband. Question: explain Gandhism and Sarvodaya movement in India. 21st century is the era of globalization. New economic policy of globalization moves on to make the world a global village. New challenges and problems have emerged before youth. The belief that all emergent problems, ecological, social, economical, political and moral could be resolved by discoveries and technological innovations persists, features in the past notwithstanding. What is happening today is in line with what Gandhi almost predicted in Hind Swaraj as he prepared its manuscript in 1908. Gandhi put forward 4 main goals before Youth for Humanity, so as to move towards its destiny. These are Swaraj, non-violence, Swadeshi and Sarvodaya. These are the main pillars of the thesis he has propounded in the Hind Swaraj. In this paper an attempt is made to focus on Sarvodaya as one of the pillars to bring Hind Swaraj. Objectives of this research paper are to know Gandhian philosophy of Sarvodaya for changing attitude of youth and aware youth for their rights and duties. Primary and secondary resources are used for this paper. Meaning of Sarvodaya. Sarvodaya is a term meaning universal uplift or progress of all. The term was first coined by Mohandas Gandhi as the title of his 1908 translation of John Ruskin's tract on political economy, unto this last, and Gandhi came to use the term for the ideal of his own political philosophy. One later Gandhian, like the Indian non-violence activist Vinoba Bhave, embraced the term as a name for the social movement in post-independence India which strove to ensure that self-determination and equality reached all strata of India's society. Inspirations from Ruskin's book. Gandhi received a copy of Ruskin's, unto this last, from a British friend, Mr. Henry Pollack, while working as a lawyer in South Africa in 1904. In his autobiography, Gandhi remembers the 24-hour train ride to Durban, from when he first read the book, being so in the grip of Ruskin's ideas that he could not sleep at all. I determined to change my life in accordance with the ideals of the book. 2. Gandhi advances the concept of Sarvodaya, which were based on 3 basic principles. That the good of the individual is contained in the good of all. That a lawyer's work has the same value as the barber's inasmuch as all have the same right of earning their livelihood from their work. That is a life of labor, i.e., the life of the tiller of the soil, and the handicraftsman is the life worth living. The first of these I knew. The second I had dimly realized. The third have never occurred to me. Unto this last, made it clear as daylight for me that the second and third were contained in the first. I arose with the dawn, ready to reduce these principles to practice. Simple living and high thinking. Mahatma Gandhi was of the firm view that the earth provides enough to satisfy every man's needs, but not for every man's greed. In the Sarvodaya society of his dream, therefore, every member will be free from any greed for limitless acquisition of material wealth and more luxurious living, and they will follow the motto of simple living and high thinking. Everyone will, thus, get ample opportunity to produce and earn sufficiently through honest work for decent and dignified living. Consequently, there will be no problem of unemployment. Of course, obviously, income of different people may be different, depending on their talent, ability and effort. But those who will earn more will use the bulk of their greater earnings for the good of the society as a whole. In such a society, all wealth, including land, will be assumed as common property to be utilized for the welfare of all. If an individual has more than his proportionate portion, he becomes a trustee of the excess wealth for the benefit of the less fortunate members of the society. As regards use of machinery in economic activity, Gandhi said that, if we feel the need of machines, we certainly will have them. But there should be no place for machines that concentrate power in a few hands and turn the masses into mere machine minders, if, indeed, they do not make them unemployed. In order, therefore, to minimize use of machines in a Sarvodaya society, Gandhi strongly advocated that everyone should do some productive physical work at least to earn his/her daily bread, as was also advocated by Leo Tolstoy, the great Russian thinker and writer, and everyone should uphold the dignity of labor irrespective of the type of honest labor performed by an individual. Objects of Sarvodaya movement. The Sarvodaya movement has as its target the establishment of a whole network of such self-supporting village communities. The family relationships which are confined at present to the blood group will be extended to cover the whole village, where distinctions based on race, creed, caste, language and so forth will completely be eliminated. Agriculture will be so planned that all the people will have enough to consume. Industry will be conducted on a cottage basis till all the people in the village are gainfully employed. The needs of the village will be determined by the people of the village themselves, through village council, representative of the whole village. Principles of the Sarvodaya. There is no centralized authority, and there is political and economic atmosphere in the villages. Politics will not be the instrument of power but an agency of service, and Rajniti will yield place to Lokniti. All people will be imbued with the spirit of love, fraternity, truth, non-violence and self-sacrifices. Society will function on the basis on the non-violence. There will be no party system and majority rule, and society will be free from the evil of the tyranny of the majority. The Sarvodaya society is socialist in the true sense of the term. All calling will be the same moral, social and economical values. The individual personality has the fullest scope for development. The Sarvodaya society is based on equality and liberty. There is no room in it for unwholesome competition, exploitation and class hatred. Sarvodaya stands for the progress of the all. All individuals should do individual labor and follow the ideal of non-possession. Then it will be possible to realize the goal of, from each according to his work and to each according to his needs. There will be no private property, the instrument of exploitation and the source of social distinctions and hatred. Similarly, the profit motive will disappear, rent and interest too will go. The Sarvodaya movement is based on truth, non-violence and self-denial. The Sarvodaya movement makes a sincere and bold attempt to create the necessary atmosphere to bring together such individuals with an unwavering faith in the welfare of all. The gain to the individual would be small. The development of each quality depends upon every other. If all the qualities are improved a little, then the individual would gain more. Sarvodaya movement. Gandhi's ideals have lasted well beyond the achievement of one of his chief projects, Indian independence, Swaraj. His followers in India, notably, Vinoba Bhave, continued working to promote the kind of society that he envisioned, and their efforts have come to be known as the Sarvodaya movement. Anima Bose has referred to the movement's philosophy as a fuller and richer concept of people's democracy than any we have yet known. Sarvodaya workers associated with Vinoba, J.P. Narayan, Dadadhar Madhikari, Dhirendra Mazumdar, Shankar Rao Dio, K.G. Mashruwala undertook various projects aimed at encouraging popular self-organization during the 1950s and 1960s, including Bhudan and Gramdan movements. Many groups descended from these networks continue to function locally in India today. 5. Agency of Common Welfare. That Sarvodaya is an agency of service for common welfare. Sarvodaya sets its face squarely against the politics of power and exploitation. It lays great emphasis on moral and spiritual values. It seeks to create new social and economical values. The concept of possession yields place to the concept of trusteeship. People will work for the good of all, and family feeling will animate the entire community. There will be fullest scope for freedom, fellowship and equality. The state is to be an agency of power. Gramrajya is a base of non-violence. Sarvodaya stands for good of all and not for the good of any particular individual or class. Bhudan at the early stage, Gramdan at a later stage, and Sampatidan will bring about a change of heart. The rich and poor will give up their ideas of attachment to private property and will strive to work for the good of all. So, lastly, we can conclude that Sarvodaya ideals are not practicable. Though the ideals of Sarvodaya will be noble. Nobody can find fault with them, in the actual world. They will be found wanting. It will be almost impossible to establish a society strictly on the basis of great principles by Mahatma Gandhi and others. Sarvodaya doctrines are soaring, and it is doubtful whether they can rest on the earth. The poor record of Panchayat Raj in India bears testimony to the backward condition in which people are. In the highly competitive world, one country cannot succeed in having Gramraj. Unless all states in the world accept the Sarvodaya idea. The chances of having it is a particular country like India are bleak. As well as, it is difficult to bring a change of the heart in the youth, who is given to selfishness. People donated useless land in response to the Bhudan. Question. Power to the people has been materialized through the establishment of Panchayat Raj. Comment. The Panchayati Raj system is an Indian decentralized form of local self-government that attempts to deliver democracy to the people. The word, Panchayati Raj, literally means, ruling by the village council, and refers to the rural local government system. The Panchayati Raj system was adopted as a constitutional amendment in India in 1992 with the goal of decentralizing authority and increasing democratic participation at the grassroots level. It is a crucial component of India's democratic system since it allows local people to participate in decision-making, facilitates the delivery of services and infrastructure at the local level, and promotes accountability and openness. The Panchayati Raj system is divided into two tiers or levels, the Gram Panchayat, village council, and the Panchayat Samiti, block or taluka level council. The Gram Panchayat is in charge of a single village or set of villages, whereas the Panchayat Samiti is in charge of a group of Gram Panchayats. A third layer of Panchayati Raj institutions, known as the Jilla Parishad, District Council, has also been established in several states. The Jilla Parishad is in charge of managing district development and coordinating the operations of the lower level councils. Background: in India, the Panchayati Raj system is a decentralized type of administration aimed at bringing democracy closer to the people at the grassroots level. It changed throughout time due to different constitutional modifications and policy changes. The system may be traced back to the 1957 Balvantarai Mehta Committee report, which advocated for the development of Panchayati Raj institutions to decentralize power and promote local self-governance. However, the Panchayati Raj system was not fully recognized and given constitutional standing until the 73rd and 74th Constitutional Amendments of 1992. The 73rd Amendment introduced panchayats at the village, intermediate, and district levels, while the 74th Amendment introduced municipalities at the city, town, and urban agglomeration levels. These amendments provided for the direct election of members of these institutions, the reservation of seats for women and marginalized groups, and the devolution of powers to these institutions in various areas of governance. Since the introduction of the Panchayati Raj system, there have been several milestones in its development. The National Panchayati Raj Day is celebrated on April 24 each year to mark the passing of the 73rd Amendment, and several policy initiatives have been undertaken to strengthen the system. These include the Rajiv Gandhi Panchayat Sashaktikaran Abhiyan, the Panchayat Empowerment and Accountability Incentive Scheme, and the E-Panchayat Mission Mode Project. 2. Panchayati Raj System. The two-tier Panchayati Raj system is an Indian centralized governance system that involves the formation of two levels of local self-government institutions, namely Gram Panchayats and Panchayat Samitis. Gram Panchayats are the system's fundamental components, in charge of governing villages or groups of villages. Each Gram Panchayat is made up of a directly elected Sarpanch, village leader, and other people elected members known as Pachas, councillors. Gram Panchayats are in charge of providing basic facilities such as water, sanitation, healthcare, and education in the community. The 73rd Amendment to the Indian Constitution, passed in 1992, established the two-tier Panchayati Raj system with the intention of advancing local democracy and giving people more control at the local level. It has contributed to increased public participation in the government process and the growth of the nation's rural areas. The system is composed of two tiers, the Gram Panchayat, village council, at the village level, and the Panchayat Samiti, block council, at the block or taluka level. Here are the roles and responsibilities of each level. Gram Panchayat. The Gram Panchayat is the lowest tier of the Panchayati Raj system and is responsible for governing a single village or group of villages. Its primary functions include planning and implementing rural development programs and schemes within its jurisdiction, maintaining and developing community assets such as roads, water supply systems, and public buildings, implementing government welfare programs such as MNREGA, ICDS, etc., resolving disputes and conflicts that arise within the village, collecting taxes and fees as authorized by the state government, maintaining records and registers of births, deaths, and marriages in the village. Panchayat Samiti. The Panchayat Samiti is the second tier of the Panchayati Raj system and covers a group of Gram Panchayats within a block or taluka. Its primary functions include coordinating the development activities of the Gram Panchayats under its jurisdiction, planning and implementing block-level development programs and schemes, providing support and guidance to the Gram Panchayats in their development activities, ensuring the effective delivery of government welfare programs at the block level, mobilizing resources for rural development activities, maintaining records and registers of births, deaths, and marriages within its jurisdiction. 3. Panchayati Raj system. It is the primary unit of local self-government at the village level. It is made up of panchayat members, who are elected for a 5-year tenure. The Gram Panchayat is in charge of essential services like sanitation, drinking water, street lighting, and village road maintenance, among other things. It is the intermediate stage of local self-government for a group of villages. The Panchayat Samiti is in charge of planning and implementing several development projects at the block level. It is composed of delegates elected from each of the Gram Panchayats under its jurisdiction. In India, the 3-tier Panchayati Raj system is a kind of decentralized government. It consists of 3 tiers of institutions for local self-government, each with unique duties and authority. Gram Panchayat, village level. The Gram Panchayat is the primary level of the Panchayati Raj system, responsible for governing and managing village-level affairs. It comprises elected representatives who oversee the development and progress of their respective villages. The Gram Panchayat is responsible for executing essential rural development programs such as sanitation, primary education, healthcare, drinking water supply, and social welfare initiatives. Additionally, it maintains accurate records of vital events such as births, deaths, and marriages occurring within the village. Panchayat Samiti, block level. Sitting between the Gram Panchayats and the Jilla Parishad, the Panchayat Samiti constitutes the intermediary tier of the Panchayati Raj system. It comprises a group of Gram Panchayats and serves as the governing body for a block or taluka encompassing multiple villages. The Panchayat Samiti plays a pivotal role in coordinating and supervising the functioning of the Gram Panchayats under its jurisdiction. Additionally, it oversees the execution of diverse rural development schemes and programs pertaining to agriculture, animal husbandry, and rural industries. Jilla Parishad, district level. At the apex of the Panchayati Raj system, the Jilla Parishad serves as the topmost tier representing the district-level administration. It is composed of elected representatives from the Panchayat Samitis and shoulders the responsibility of overseeing the holistic progress and growth of the entire district. The Jilla Parishad acts as the nodal agency that coordinates and monitors the operations of the Panchayat Samitis falling within its jurisdiction. Moreover, it devises and executes a diverse range of schemes and programs catering to the district's needs concerning education, healthcare, agriculture, and rural development. Comparison between 2-tier and 3-tier systems. The most prevalent types of systems utilized in decentralized governance are 2-tier and 3-tier systems. The number of levels of government and the roles they play varied between these systems. Similarities between the 2-tier and 3-tier Panchayati Raj systems. Both systems aim to promote grassroots democracy and decentralize power to the local level. Both systems have elected representatives at the village or ward level. Both systems have provisions for the reservation of seats for women and marginalized communities. Differences between the two-tier and three-tier Panchayati Raj systems. The village level and the block level are the only two tiers of government in the two-tier system. The three-tier structure, on the other hand, consists of three levels: village, block, and district. Comparing the two-tier and three-tier systems, the two-tier system has fewer elected representatives. For instance, the two-tier system in Uttar Pradesh only has 2 representatives per village, but the three-tier system in Kerala has 4 representatives per village. Comparatively speaking, the two-tier system has fewer administrative duties than the three-tier structure. For instance, the block level in a two-tier system only has a small number of administrative duties, whereas, in a three-tier system, the block level is responsible for a large number of administrative duties. Advantages and disadvantages of the two-tier Panchayati Raj system. Advantages. In comparison to the three-tier system, the two-tier system is simpler and easier to implement. Due to fewer elected representatives and administrative duties, the two-tier system is more economical than the three-tier system. Local communities can participate and be more actively involved in decision-making thanks to the two-tier approach. Disadvantages. Larger states that require more decentralization of power may find the two-tier structure ineffective. When dealing with complex problems that demand a higher level of administrative competence, the two-tier structure could not be effective. Due to the lower number of elected members, the two-tier system may not be as effective in guaranteeing the equitable allocation of resources. Question: how are the prisoners' rights protected under our Constitution? Briefly explain. Every living being is born free and has equal rights. No one, including prisoners, shall not be subjected to torture or cruelty. Prisoners are also human beings and have a right to an appropriate standard of living, including food, drinking water, accommodation, clothing and comfortable bedding. The Prisons Act of 1894 was in place throughout the time of British administration in India, but the rights were consistently violated since the foreign and domestic convicts were treated differently due to prejudice. Due to the reality that a prisoner is always still a human being, the authors of the Indian Constitution decided to grant prisoners some rights when India gained independence. A prison is a location that is suitably set up for offenders to be kept in safe custody while being tried or punished. At first, it served only as a holding facility or a detention for criminals awaiting trial and the final punishment, but there came a point where incarceration gained legitimacy on its own. Earlier legislation regarding the rights of prisoners. Our present system went through a significant modification once we gained our independence in 1947. The government showed particular interest in it. A team of specialists from the United Nations were asked to examine the jail system, and it was said that they made some recommendations to improve prisoners' rights. It is shocking to see that many developed nations, including China and India, still lack legislated prisoner rights, yet our honorable judiciary has recognized a large list of these rights, and the government still continues to fight for the welfare of the inmates. Even after punishment, a prisoner continues to be a living, breathing human being. Consideration has to be such a human being since he is also a citizen of India. The right to dignity guaranteed by the Indian Constitution is not diminished by the legal restrictions placed on one's freedom. Even within bars, she or he is still entitled to basic human rights. The Prisons Act of 1894, a century-old act, had established state laws in India that control prisons. There are, however, very few states and union territories that have laws or regulations that were created in the 21st century, including the Andaman and Nicobar Islands, Arunachal Pradesh, Bihar, Daman and Diu, Delhi, Goa, Sikkim, and West Bengal. The modifications made to these state laws haven't done much to advance the body of law that, among other things, protects prisoners' rights. Articles granting rights to prisoners. Article 14. According to Article 14 of the Indian Constitution, the state shall not deny to any individual within the territory of India the equality before the law or the equal protection of the laws. As a result, Article 14 of the Indian Constitution introduced the concepts of reasonable classification and the idea that love should be treated similarly. The Constitution of India, and in particular, the Article 14 and its fundamental freedoms, serve as a guide and foundation for the jail authorities to identify different prisoner categories and their classifications with the goal of reformation. Human dignity is integral to human rights. In a series of rulings, the Supreme Court has expressed grave concern over the inhumane treatment of prisoners and gave the appropriate instructions to the prison and police authorities for protecting their rights. A human being's treatment that violates human dignity, subjects him to unnecessary agony, and lowers him to the status of a beast would undoubtedly be arbitrary and subject to challenge under Article 14 of the Indian Constitution. Article 19. 6 freedoms were guaranteed to all Indian people by Article 19 of the Constitution. These freedoms include, for example, the right to free speech and expression under Article 19, 1a, and the right to join an association. Just as these freedoms are available for the citizens of India, detainees also have a right to utilize them. However, the government may pose restrictions if and when required to exercise caution is the utility of such freedoms by prisoners. Article 21. No one must be deprived of their life or personal liberty, except in accordance with a legal process, according to Article 21 of the Indian Constitution. The right to life and the idea of liberty are two ideas that are outlined in this article. It is made plain by Article 21 of the Indian Constitution that it is open to both free and confined individuals. Rights of prisoners. Right to legal aid. Although the Indian Constitution does not clearly establish the right to legal aid, legal professionals frequently show generosity to prisoners who cannot pay it or who could voluntarily contact a legal advisor. The 42nd Amendment Act, 1976 lists free legal aid as one of the directive principles of state policy in Article 39- of the Indian Constitution. Although the Constitution's article on free legal aid is the most important and explicit, courts may not always have the authority to enforce it. Nonetheless, following these rules is essential to applying the right laws. According to Article 37 of the Indian Constitution, the state must follow these guidelines. Right to speedy trial. The saying, "Justice hurried is justice worried," refers to how important a speedy trial is to a fair trial. Hence, a balance must be struck between the accused's right to a swift trial and the prosecution's right to a fair opportunity to prove the accused's guilt. Article 21 of the Indian Constitution is where the idea of a fast trial originates. One of the key objectives of the criminal equity conveyance system is the expeditious trial of crimes. Immediately after the court accepts the allegation, the prosecution must be instructed to reject the guilty party and clear the innocent one. The fundamental principle of civilized criminal law is that a person is deemed innocent until they are found guilty of the charged offense. Article 14. 2. Of the 1966 International Covenant on Civil and Political Rights recognizes the presumption of innocence as a human right. According to Article 11, 1, of the 1948 Universal Declaration of Human Rights, anybody accused of a crime has the right to a public trial where they will be deemed innocent unless proven guilty in accordance with the law and will be given all the protections essential for their defense. Right to a fair trial. It wouldn't be an overestimation of things to say that a fair trial is the edifice of criminal law and, in a sense, an quintessential component of a democratic, rule of law-based society. Denying a fair trial is equivalent to crucifixion of human rights. It is ingrained in the idea of fairness in the legal system. While emphasizing the principle of a fair trial and the application of the same during the trial, it is required of the courts to determine whether, in a particular case or category of cases, reversal of the judgment of conviction due to non-compliance with a certain provision is inevitable or depends on reaching an undisputed conclusion that substantial injustice has occurred. Right to live a life with dignity. The Indian Constitution guarantees every citizen the right to live a life of dignity. The prisoners are likewise granted this privilege since their conviction does not render them inhuman. This right is a crucial component of the Indian Constitution's provision of the right to life. Every person's life is valuable, and, regardless of the circumstances, they should be treated with dignity to enable them to continue living. Right to meet one's family. The scope of human rights is an ever-growing concept and prisoners' rights have been acknowledged equally in order to spare them from both physical suffering and mental torture. The right to interview one's family and friends is unquestionably covered by the personal liberty guaranteed by Article 21 of the Indian Constitution. Prisoners ought to receive both physical and mental protection. Individuals must get together in order to exchange information. This is a basic human right. Being their legal agents, consult attorneys, make decisions that directly impact the case of the convicted. The visits from friends and family members provide them the mental stability they need to endure in such a terrible situation where no one knows each other. Right to life and personal liberty. The Honorable Supreme Court has frequently upheld the relevance of Article 21 and applied its ruling in several cases. The meaning of the word, life, as used by Field J in the well-known case of Karak Singh v. State of UP, has been broadened. In the aforementioned instance, the court decided that the term, life, refers to more than just an animal's existence. The prohibition against its loss applies to all the limbs and faculties that are used to enjoy life. The law also forbids the destruction of any other part of the body through which the soul communicates with the body, such as an arm or a leg, an eye, or another organ. Landmark cases. In the depths of Article 21 of the Indian Constitution, the Honorable Courts of India have introduced various fundamental rights for prisoners. In the case of Sunil Batra v. Delhi Administration, it was decided upon that prisoners have the right to visits from their family members in order to protect them from mental torture and maintain mental peace. This was a landmark decision that also upheld the right of prisoners to mental health. Every person has rights that are protected by Article 21 and cannot have those rights violated. not even by the state's authority. In the case of State of Maharashtra v. Prabhakar Pandurang found that a prisoner has the right to express their feelings in writing and can publish that in the framework of the right to personal liberty. The second right is to pay fair wages to prisoners for the work they have performed while incarcerated. This has been done in numerous precedents, including Mehammed Jayasuddin v. State of AP, People's Union for Democratic Rights v. Union of India, State of Gujarat v. Honble High Court of Gujarat, and Gurudev Singh v. State of Himachal Pradesh, with the goal of enabling prisoners to lead self-sufficient lives after their release. To be specific, it was decided that compensation must be paid and should not be less than the minimum stipend. Conclusion. One of the worst groups of human beings destined to experience a clear fundamental right being violated is prisoners. The Supreme Court has reaffirmed the principle that the loss of fundamental rights does not result from imprisonment. The Supreme Court has so formally stated that a prisoner's fundamental rights remain an enforceable reality, even if they are constrained due to their incarceration. Thus, one could argue that while incarcerated, inmates are still entitled to all of their fundamental rights. Although the Indian Constitution does not openly and explicitly guarantee prisoners' rights, Articles 14, 19, and 21 do so inferentially. Moreover, the Prisons Act of 1894 has measures for the welfare and safety of prisoners.